Here, please, the Lordship.
Yes.
Lordship, this is a revision petition against the impugned judgment dated 29/10/2025,
Correct.
passed by the Learned Court of Civil Judge Senior Division, wherein Lordship, the impugned order was partially modified and interfered. And the case of the petitioner is that the respondent herein filed the TS case number 40 in a municipal court, Nagaon, for declaration of right, title, and interest over suit land, recovery of khas possession by evicting the defendants, and for the cancellation of sale deed, permanent
No,
exile
madam, you see,
for proceeding.
in the appeal, one decree was passed.
Yes, Your Lordship.
Whether this revision petition is maintainable.
Lordship, may I clear my facts, Lordship?
Pardon?
May I clear my facts, Lordship? This is maintainable, Lordship, because the entire land belonged to me.
No,
But I
no.
was-
Whether second appeal will lie or revision will lie. It is appellate decree.
Yes, Your Lordship.
Whether civil revision petition will lie.
Lordship, I just want to modify the appellate court order, Lordship. It has
No,
been given in my
modify.
name only,
No,
but
no.
Lordship.
It can be modified when the second appeal is filed. But this civil revision petition is not maintainable.
Lordship, then
You see this appellate decree it is.
Lordship, then I may be given
You see section 100. Did you see?
115, Lordship. Section 115.
No, 100.
Or 100. Yes, Your Lordship.
Subsection 2, an appeal may lie under this section from an appellate decree. Subsection 1. 2 is relating to ex parte. It is not an ex parte decree, it is an bipartite decree.
Yes, Your Lordship. Lordship, then I may be given liberty to file.
And also say order 43, rule order 43, rule 1. Third miss, your name please.
A. Hussain.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that she may be permitted to withdraw this petition with a liberty to file. No, with a liberty to approach this court again by filing appropriate petition where allowed. This CRP stands a disposal on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Number 36.
May I please, Your Lordship? Lordship, kindly pass away the matter for time being, Lordship.
Item number 12 for ordinance.
My lord, herein this case till date, they have not released the amount. And on the other hand, my lord, they are sought for different documents from the petitioners, my lord. And on the other hand, my lord, they kindly see the instruction which is given by my learned friend on the day. And if we go through the, if we go through the,
Khatonia. NJ Khatonia. Yes, what happened?
My lord, what happened? Kali peruse the judgment, my lord. In my contempt proceeding, page 16, my lord. Relevant portion. My contempt petition, my lord.
Page number?
Page number 16, my lord. The relevant portion, para 17. Got it, my lord? Para 17, in the instant case, the petitioner were appointed in the year 1989. They have rendered the service more than 28 years now. As a matter of fact, they were paid salary up to July 2007. That is for a period of 18 years. Continuous in service by the petitioner is not disputed. And as per the admitted stand of the respondents, no termination order has been issued to the petitioners. In such circumstances, withholding of the salary of the petitioner would not be justified. Consequently, impugn order dated so and so is set aside and quashed. Respondents are directed to release the arrear salary of the petitioner from August 2007 within a period of 4 months from the date of receipt of the certified copy of this order. Current salary for the month of February 2007 shall be released within a period of 3 months from the date of receipt of the certified copy of this order. Petition is allowed, but without any order of cost. My lord, the last instruction your lordship has given by my learned friend. Here, my lord, I have gone through the same, and I have seen in some petitioners they have released the salary from 2009 to 2015, and the amount has given in very, my lord. In some cases 1 lakh, in some cases 1,20,000. So, as per the direction of this honorable court, the order has not yet been fully complied, my lord.
No, whether you have received this amount.
No, not yet.
Okay.
That receipt has also not been released to us.
Attorney মাথায় দিব না। এসিটা চলাইছেন? চলাই দিন। Attorney,
Yes, sir.
whether the amount was credited in the account of the petitioners?
Yeah, well, that is a question I don't have one today. I thought because it was sanctioned on 9th. So I thought that's already been credited. So I'll obtain instructions to direct it.
And further, he has also pointed out that the amount, actual amount they have, which the petitioners are entitled to, has not been given to them.
That, my lord, I cannot say right. Because according to the attendance, amount has been calculated.
No, not attendance. As per direction of this court,
So some of them were not attending their duties. That report was there.
Direction is not there.
Continuance of service, not.
They are not working, they will definitely they will not get the amount. So in fact, while file an affidavit to the effect, most of them are not working after that. 2007, some of them are not working. So according to the attendance, amount will calculated. In any case, regarding whether the amount has been credited or not, that information I will obtain well. Let me fix it on Friday. Friday I can.
no, Mr. Khatoniar, you see, if there is any difficulty in complying with the order of this court, you ought to have filed an application or file an affidavit
Yes,
indicating that how you are not in a position to comply with
That I
the.
can do.
That is very much required, my lord. That cannot they deviated from the order, my lord. And to that effect, my lord, the Supreme Court judgment is also there.
They are not working for some time, definitely they will not. That is a
No, settle all right, but you have to indicate
Yes, that I will do, my lord.
In that case, they have ought to have been challenged or file a review petition. Your direction is very clear. So let them file an affidavit, my lord.
heard Mr. Islam, learned counsel for the petitioner, and Mr. N.J. Khatonier, learned counsel for the contender. Mr. Islam, learned counsel for the petitioner, submits that though some of the amount has been sanctioned in the name of the petitioners, the said amount is yet to be credited in their account. Mr. Khatonier submits that he may be granted some time to obtain instruction in this regard. Fair allowed. Mr. Islam also pointed out that the order of this court passed in WPC number 3286 of 2014, dated 17/2/2017, has not been fully complied with, as the actual amount which the petitioners are entitled to as per said order has not been sanctioned. At this instance, Mr. Khatonier submits that the petitioners were not working for some of the period for which the amount they entitled to has not been paid, and to that effect, he will file an affidavit before this court. And he prays for granting him some time, bear allowed, rest the matter after 1 week or 2 weeks.
2 weeks.
After 2 weeks. In the meantime, Mr. Khatonier shall file affidavit as to why the order of this court dated so would not be complied with fully. And he will also obtain instruction in respect of the amount that has been sanctioned by the respondent authorities. Person to the order dated 10/2/2026. List accordingly.
Much appreciated.
Items 13 and 14.
The dead did it.
13 and 40, my lord, take up after some time, my lord. They are sending the instruction, my lord. Once I get it, my lord, I will inform the. I will inform the board.
And then 15.
My lord, here we have brought the sole respondent has died. So we have brought his legal heirs to be substituted in place of the sole respondent. And we have, there is a delay of 173 days because we could come to know that he is the sole respondent has 2 wives and his children are there. So we took some time. And furthermore, my lord, I had some problem in Calcutta regarding the family dispute of the sharing the property. So I had to go there in Calcutta. So after this disposal of this Calcutta matter, then I came and I have filed this thing. So there is a delay of 173 days. So such delay may kindly be condoned and the
Yes.
May give us, kindly give us 2 weeks time to
Or-
file objection.
It is IA's file in the year 2023, already 3 years elapsed. Again,
The last tranche may be given.
heard Mr. Nande, learned counsel for the applicant, and Miss
Jay Sharma on behalf of A.
Learned counsel appearing on behalf of Mr. A. Iqbal, learned conducting counsel for the opposite party. Ms. Sharma submits that the respondent may be, opposite party may be granted 2 weeks time to file objection. Pair allowed recess and list the matter on fixed date.
Mark,
15.
Hi.
Biplab.
I think 36 for motion.
My lord, this is an application under 227, my lord, 115 of the CPC, my lord. The impugn order that is annexed 4 at page, my lord, 35. But where happened, my lord, in this case, the petitioner, before your lordship, my lord, on issuing on, my lord, the notification by the respondent numbers, my lord, general secretary and president, along with the my lord, one election officer to hold the AGM and to at the same date, my lord, to hold the election also, my lord, the flouting the provisions of the rule 15, 16 and 17 of the society's regulation. So on that issue, my lord, he has filed one, my lord, this title suit 10 of 2026 along with the Miss J case number 18 of 2026. Well, for under order 39 rule 1 and 2, well, for injunction, temporary injunction, and my lord, the issuing notice. Well, on that issue, well, what happened, my lord? On 17/2, while the matter was taken up, the honorable, my lord, the learned trial court, it is civil justice division, my lord, came to the my lord, some erroneous findings that he found that well, 2 caveats that is been filed on 12/1 and the 3/2. It is been, my lord, so pending. So without issuing the notice, my lord, this matter cannot be decided. And although the meeting was to be scheduled to be held on, my lord, 1/3, the notice was issued to returnable on, my lord, 5/3. So otherwise, my lord, the entire, my lord, the effort of the petitioner, it is will be, my lord, the infrastructure by this time. But thing is that, my lord, so far this caveat is there. Well, like lordship, I'll show the, my lord, the annexer 5 and 6, my lord. This is Miss caveat number 2. It is been filed by the same society against one Sanjay Jain, my lord, not against me. And the second one also, that is in the civil justice senior division, by the same, my lord, society against the Sanjay Jain, not against me. That is in annexer, my lord, 6 at page 42. So moreover, my lord, in earlier occasion, why these things happen, in earlier occasion, my lord, this Sanjay Singh, on the similar attempt by the same society, the flouting the provision of 16, 15, 16 and 17, tried to hold the meeting, my lord, by which they tried to, my lord, accept the audit report of last 3 consecutive years, but without following the procedure. On that, my lord, another title suit was filed with an injunction petition. That injunction was not allowed. Then another, my lord, miss appeal was filed. And that in miss appeal, the matter was heard and matter was remanded back by staying the order. Against that, my lord, society has come before your lordship for a revision petition. In that revision petition, my lord, while the matter was decided by this honorable court, lordship will get a page. It is started from annexer 2 at page 19. The same issue, my lord. It is specifically on the submission of the society's advocate. It is lordship will come to page 25 of paragraph 19. Lordship got it, my lord? My lord, it also appears that even the event of application under order 39 rule 1 and 2 of Code of Civil Procedure 1908 by the present application before this trial court seeking temporary injunction, the main grievances of the present respondent is not compliance of the requirements of the provides under the rule 15.1b and Roman 3, which is the petitioners are ready to comply. That this now respondent, the same petitioner of the society, it also appears that on the perusal of the plain, a copy of which is annexed along with his revision petition. It also appears that no prayer for the issuance of the caveat injunction was made by this present application, which itself weakened the case for granting of a temporary injunction. In that, my lord, miss appeal. Next para, my lord, the appears that for the which it appears that the trial court by filing a title suit number have lapsed as the petitioner are ready to comply with the requirements of the Rule 15, B1, then B, Roman 3 of the relevant rules and regulation, as well as the other reasons stated above. No purpose will be served by reviewing the misdeeds numbers, such and such and. Next, my lord, para, if the court therefore set aside the impugn order passed by the court of the learned additional session judge Dibrugarh in the misappeal number 1, subject to the condition that the petitioner may hold the AGM after complying with the provisions of rule and regulations of these three Vishwanath Marwari Dattavya Sudhalaya is issuing it a fresh notice. My lord, after this, my lord, this notice, that is, my lord, annexure 1. Lordship will get page 18. By which, my lord, the notice was issued on, my lord, 3-2, by which the president and the general secretary, my lord, kindly see the, my lord, agenda. My lord, we are agreed by the agenda number 3, 4, and 6, my lord. Same thing was
Maybe
earlier.
here you were challenging the order dated 17/2/2023.
Yes, my lord.
Here the trial court has found that 2 caveats have already been filed
Yes.
and therefore issued notice. What wrong with this order?
My lord, the caveat was not against me, my lord.
Hmm.
Caveat was not against me.
Maybe, but in that case
No,
it
my
has
lord,
been filed.
that even, my lord, whenever the matter is, my lord, scheduled to be fixed on 1-3, then what is the necessity, my lord, again, to fix the matter on to after 4 years, 4 days, my lord.
Hmm.
By this time, everything will be over. And lordship kindly see, I am coming to, my lord, that things. Well, notice kindly see this for the agendas. My lord, the agenda number 3, my
No,
lord.
no, we'll not
No,
go
my
to
lord,
the agenda. Sorry.
No, my lord, one thing, my lord. The rule, my lord.
No, 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 no.
No, my lord, kindly one thing, my
We
lord.
are testing this order
No,
only.
my lord, kindly appreciate one thing. My
Sorry,
lord.
sorry.
My lord,
We'll not go
kindly-
to the merit of the
Kindly,
case.
kindly appreciate one thing, my lord.
Sorry.
Whenever, my lord, earlier revision petition
No,
was,
no,
my lord,
no,
disposed
no.
of, court has stated that he has party
No,
compliance of the
no, we
rules
have to
15 and 16.
confine only to this order dated 17/2/2026.
No, my lord, then what is the one of the meaning of this passing of the earlier civil division order, my lord?
No,
Because
should
that is
we-
not as
no,
per
no.
compliance of.
You tell me while testing this order, can we go into that aspect?
No, my lord, this earlier occasion, the same
no, this is
similar, my
civil
lord,
division
agenda was
petition.
issued. No, my lord, kindly see, my lord.
Sorry.
My lord, rules, my lord, I am annexing the rule also, my lord. Kindly see that they cannot hold the, my lord, meeting for.
No, you tell me how this order is suffering from perversity.
My lord, because my lord,
Tell me.
caveat was not against me. Caveat was for another person. I have filed the case, my
No,
lord.
in this case it was filed.
Yes, my lord.
Then
I was not, my lord, against me, caveat was not pending. That was
Sorry.
another person that caveat was pending, my lord.
next matter, we dismiss the petition.
My lord, kindly appreciate, my lord.
Sorry.
Number 16.
Must have, my lord.
May I please your lordship? As per office note dated 8/9, the sole respondent have appeared, but I don't know where he is. Your lordship,
Someone has filed Kalatnama on
Yes,
the
we-
earlier occasion.
we have filed Ukalat number.
Pardon?
We have filed Ukalat number.
You are for the
Petitioner.
petitioner.
Yes,
Petitioner.
yes, your lordship.
You are for the petitioner or respondent?
Petitioner, your.
No, for respondent also one counsel has filed Kalatnama.
I think his name is D Das.
Pardon?
D Das.
Pardon?
D Das, your lordship. I think so. His name has been shown. D Das, Mr. D Das.
Heard miss your name, please?
R. Kalita, lordship.
Learned counsel for the petitioner, none appears for the respondent on call. Though one advocate entered appearance by filing Ukalatnama as per office note dated 8/9/2025. List the matter for admission on fixed date.
16th March.
sorted.
Much obliged.
11 March. Item 17.
May I please, Lordship? My Lord, I have filed this civil division petition challenging the order dated 25/5/2023
Hmm.
issued passed by the London Municip number 4 Kamrup Metro Gauhati, whereby my petition filed under section 10 of the CPC was rejected by the London Municip.
Hmm.
And notice was issued to them, Your Honor. All the respondents have appeared. So there was,
You are for the respondent,
yes, all the.
Suddenly come up for admission.
admission, yes.
But my prayer is that as the Your Honor, there is a prayer for stay of the interim order dated 25/5/2023. On the last occasion, Your Honor, my Lord, on 24/2/2023, my Lord, 24, my Lord, this honorable court was pleased to direct that the interim prayer for interim shall be considered on the next date. So there is a urgency in this matter.
So we will finally hear and dispose of the matter. Heard, Mr. Your name, please?
M. Agarwal.
M. Agarwal, learned counsel for the petitioner. And Mr.
M. Hassan.
M. Hassan, learned counsel for the respondent. This is the matter for admission hearing. After 1 week, 24 matter.
9th March.
9th of March.
My lord, I am sorry, my lord, may I play one thing, my lord? We already, my lord, notice is issued on injunction petition that is fixed on 5/3, my lord.
Hmm.
So meeting is scheduled to be held on 1/3, my lord.
Hmm.
So that can be preponed, my lord. I will serve the dusty service to the, my lord, all the respondents against whom the caveat is there. That can be on hard on 28, my lord. Then the purpose will be served, my lord. Otherwise, then nothing will be there. That order, my lord, only. I will serve dusty service by tomorrow.
Okay.
On 28, that may be fixed, my lord.
20th, no, not 28, prior to holding of the
But
meeting.
yes, but any
Meeting
but
is fixed
20,
on
yeah.
1st of March.
1st of March, yes.
Okay, before that.
My lord, master bless.
Item 18.
Lordship, steps upon respondent 1 and 3 has been received by Lordship. We have to take fresh steps after ascertaining the address, Lordship, as per last office note.
Heard, Miss,
As story, Lordship.
learned counsel for the petitioner. Office note dated 29/8/2025 indicates that notice issued to the respondent number 1 and 3 returned unserved. With a report, no such person in the address RTS on the envelope. The learned counsel for the petitioner submits that she will ascertain the address. No, she will obtain necessary instruction in respect of the address of the respondent number 1 and 3 and will take fresh step upon them. And she tries for listing the matter after 4 weeks.
Lordship, there's an interim order which
They are allowed. Step be taken by registered on a speed post with AD and also by usual process with any week from today. List after 4 weeks. Interim order pass earlier shall continue.
obliged, Lordship.
Item 19.
Service report is completed, Lordship, as per the office note.
Service completed. Service completed. Heard, Miss,
K. Malapur, Lordship.
learned counsel for the petitioner and Miss,
The Lordship will file an objection.
learned counsel for the respondent. The learned counsel for the petitioner submits that service in this matter has been completed. And the counsel for the respondent entered appearance and as such, the matter may be listed for admission hearing. Pair a lot, receives and list the matter after 1 week or 2 weeks.
13 March.
On
Dear-
13th of March, in the meantime, learned counsel for the respondent may file objection petition if so advice.
There is a interim order, Lordship.
Interim order pass earlier shall continue.
I'm get to Lordship.
Item 20.
In this case, service has been completed, my lord. Service has been completed. my lord.
Completed.
So it may, after 3 weeks, it may
Admission.
be posted for admission.
Admission.
Okay.
Heard Mr. Sharma, learned counsel for the petitioner. And Miss learned counsel for the respondent. Mr. Sharma submits that service has been completed in this matter and the same may be listed for admission. Hearing. Prayer allowed, receives a list the matter after
3 weeks. sir.
3 weeks.
And interim may continue, my lord.
Interim order passer shall continue.
है ना?
None appears for the petitioner on call, list the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
May I please your lordship?
Yes.
Lordship, my senior counsel has been suffering from fever and vocal infection, lordship.
Okay,
So lordship, kindly adjourn the matter for today, lordship.
okay. Heard Mr.
D.K. Bora on behalf of Mr.
Learned
L.K.
counsel
Bora.
appearing on behalf of Mr. L.K. Bora, learned conducting counsel for the petitioner, and Mr. D. Nandi for the respondent. I'm for the respondent. Mr. Bora, learned counsel appearing for Mr. L.K. Bora submits that conducting counsel Mr. L.K. Bora is indisposed of and as such he prays for listing the matter after
Any date, lordship.
18 March.
18th of March.
Deeply obliged. lordship.
Item 25.
May I please your lordship. Lordship, the matter, it's a section 115 petition, my lord, revision petition, my lord. But today it has come up for the consideration of the condonation of delay, my lord. There's a delay of 208 days in filing the connected civil revision petition, my lord.
Hmm.
On the last occasion, my lord, certain records were called from the Legal Services Authority, my lord. My ground for condonation of delay is that although the record of the case was handed over to another counsel, the same was handed over to me in the month of July 2024, my lord. As such, after
When the documents were handed over to you,
my lord, it was handed over to me on 28th of June, my lord, 2024.
when did you file this application?
My lord, it was filed on 30th day of January 2025, my lord.
And when the order was passed?
The impugned order, my lord, is it 13/12/2023, my lord,
13/12.
2023. So the
Yes, any objection?
Appearing on behalf of Mr. B. Bora, my lord. Due to some personal difficulty, he could not appear. So I was instructed to take an adjournment. my lord.
Sorted then. Let him appear. Heard Mr. K. Borwa, learned counsel for the petitioner. K.R. Borwa, learned counsel for the applicant. And Mr.
MM Zaman on behalf
M.M. Zaman, learned counsel appearing on behalf of Mr. B. Bora,
of B. Bora.
learned conducting counsel for the opposite party. Mr. Zaman submits that conducting counsel for the opposite party is indisposed of and as such he plays for listing the matter. In the next week, next week, parallel, this is a list the matter on COVID.
March 24.
All right.
26.
Replying for the respondent for what? We intend to file an objection, kindly grant us some time.
Petitioner? No, petitioner
Yes.
absent.
Absent.
None appears for the petitioner on call. How about Mr.
A Wahid.
A Wahid, learned counsel for the respondent present. Mr. Wahid submits that he may be granted some time to file objection. 2 weeks time to file objection, pair allowed. List the matter on
18 March.
18 March. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Letter 28.
Who is senior? Your senior? M.I. Hussain. Okay, Bora, wait for some time.
Yes, ma'am.
29.
None appears for the petitioner on call. Is the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
30.
Pursuant to what has fallen from your lordship on the other day,
Yes.
I made my efforts, lordship. I have not come across such, I don't know. Apni paise nahi. No, larger bench.
There are subsequent judgments. which
There are
verify
subsequent.
that Point, your lordship. I'll just raise it before the lordship.
No, look at that. 2020.
16 SCC.
Oh, 2022 was another.
Yes. Lordship, in this case, it's 2020-16 SCC.
Hmm.
230.
Hmm.
First of all, I'll take your lordship to paragraph 42. Your lordship, please, this lordship will find was discussed with regard to that Brahmadev Chaudhary's the judgment your lordship had relied upon while passing the judgment under review. The lordship will find here, let me read out your lordship. Paragraph
Para 40?
42, your lordship.
42. Okay.
If I may read out.
Yes.
In Brahmadev Chaudhary's substance, this court held that you taken by the High Court that the only remedy available to a stranger to a decree who claimed an independent right or interest in the property is to pursue a remedy under Order 21/99 was unsustainable. The court held that a stranger to a decree is entitled to agitate his or her grievance and claim for adjudication for an independent right title and interest in the decretal property given. The adjudication for independent and interest in the remedy of the disposed accordance with Order 29 Rule 99. Order 21 Rule 97 deals with the state which is prior to the actual delivery of possession and events of abstention can be adjudicated upon before the actual delivery of possession to the decree. In other words, both types of remedy are available to a stranger to a decree. That is what your lordship had held. Any person means even a stranger to a decree can file an application which my learned colleague was saying that it was only the person who has the decree or a party to a decree can file. Even in the Chaudhary's case, your lordship, para 9, which of that Brahmadev Chaudhary's judgment, if your lordship takes up Brahmadev Chaudhary's judgment, which your lordship had relied upon. In para 9, it was very clear, which has been reiterated just below this para 42, which has been there. Quoted below your lordship. In other words, both sets of remedy. If I may read out. At the bottom of the quotation, it is there. On the contrary, if your lordship sees, if your lordship has got it.
Yes.
Of quoted paragraph. On the contrary, the statutory scheme emphasized under Order 21 Rule 97, as discussed earlier, clearly guards against such a pitfall and provides a statutory remedy both to the decree holder
as well as to the obstructionists to have their respective say in the matter and get proper identification before the executive court and it is that adjudication which, subject to the hearing of appeal, would remain binding between the parties of such proceeding and separate suit would be heard with a view of setting the multiplicity of proceeding and parallel proceedings are avoided and the gamut laid down under Order 21 from 97 to 103 would remain in complete court and the sole remedy for the parties concerned having their grievance once and for all finally resolved in execution proceeding. Now again, in the next page, Your Lordship, there is another judgment of the Apex Court, which has been quoted by this. Here, Your Lordship will find, it is, I have the judgment with me, Your Lordship, and it is quoted. Under Order 1 rule, this all questions, including questions relating to right title and interest in property arising between the parties to the proceeding, in an application under Order Rule 97 to Rule 99, or their representation shall be determined by the court and not by a separate. Now, this case is referred in Srishnath versus Rajesh. I think Mr. in speaking of Twitter just when while interpreting the expression any person's health, we find that the expression any person under subclause 1 is used deliberately to widen the scope of the power so that the executive court to adjudicate the claim made in any such application under Order 21 Rule 97. Thus, by the use of the word any person, it includes all persons resisting the delivery of possession living right in the property, even those not bound by this decree, including tenants or other persons living right of their own, including a stranger, which my learned colleague says, I was a stranger in that decree that was passed, and I have filed this application under Order 21 Rule 97, which was taken up by the learned trial court. His contention was that this could not have been done because a stranger to a decree could not come in this manner as per his interpretation of Order 21 Rule 97. Your Lordship had also rightly held that any person means a stranger also that so the review which he is seeking is totally not correct in view of the settled position of law, which Your Lordship had rightly pointed out while appreciating and passing the impugned order under review. And then Your Lordship, in para 46, it has been discussed in para 46 of this particular judgment. If I may read out in Lordship. In view of the settled position of law, it emerges from above. It is evident that the appellants were entitled to were a stranger. Here also was a case where the appellants were a stranger and they had filed this application. Para 46 of this judgment. In view of the settled position of law as it emerges from the above decision, it is evident that the appellants were entitled, though they were a stranger to the decree to get their claim in possession of this independent and adjudicated in the court of execution of the proceeding. The appellant in fact set up the claim. They sought declaration of their entitlement to remain in possession in the character under Order 1 under 21 Rules 97. They were entitled to set up an independent claim even prior to that disposition. So this is what Your Lordship had rightly held, that any person means. This was what Your Lordship had stated. This is what the judgment of Your Lordship had relied upon, Brahmadhar Chaudhary. It is Brahmadhar Chaudhary itself. This was the thing that strangers can come. This is being reiterated in the subsequent judgments also. So I submit respectfully, Your Lordship, subject to further submission by my learned colleague, that Your Lordship's judgment which was passed was based upon a legal proposition which is established proposition. There was no error apparent in the face on the record. And it has been rightly held by Your Lordship that any person which upholding the trial court's judgment, it was a correct decision taken by the trial court. So my humble submission is the review my learned colleague has placed before Your Lordship, saying, interpreting Order 21 Rule 97, saying that only by curtailing the scope of 97, which the learned Apex Court clearly says, any person has widened the scope to even include a stranger. And here it is admitted, my learned colleague has himself stated that I had 5 days because I was a stranger to the decree. And I had filed it, and the court had rightly, it is not that it has been finally disposed of. He has been allowed me to contest the case and file the WS, etc. is been allowed. So I feel your lordship had rightly taken the upholding the trial court's verdict by saying that the Brahmadar Chaudhary's judgment was the correct position of law, which subsequent judgments of the apex court clearly highlights that this was the preeminence of the first judgment on that line, your lordship. And Brahmadar Chaudhary's para 9 is very clear, and even para 6 of that judgment, if I may please Brahmadar Chaudhary for it.
Lordship has quoted it in the order.
Para 6.
Para 6 and 9, Lordship has quoted.
Para 6,
That your Lordship will find at page 130 and 131. It's quoted.
your lordship see. If your lordship sees para 6,
Mm.
at the right hand side, there are some figures there, alphabets. F after the, just below F, on the left hand side, sorry, left hand side, F. If your lordship sees, in fact, any word, persons, as contemplated under order 21 rule 97, if your lordship has seen it. Are comprehensive enough to include apart from judgment debtors or any persons claiming through his given persons independent and who would therefore be total strangers to the decree. So this was just before para 9. Thus, apex court in Brahmadar Chaudhary clearly expanded the scope of any person in while interpreting this phrase any person. So my humble submission, your lordship, Brahmadar Chaudhary, which your lordship had referred to while passing the appeal judgment, was a proper appreciation of this, and this has been substantiated by the subsequent judgments of 2020, your lordship. So that is my humble submission, and even in Starline case also, which my learned colleague had referred to the last occasion, that is 98. Here also your lordship will find in which he had referred to, though he had referred to Supreme's case, this is the SCC printout. I mean, because I have the SCC printout, it would be for me to refer your lordship. Here your lordship will find, again in para 16 of this particular judgment, which my learned colleague had referred, Brahmadar Chaudhary has again been referred to. And here para 6, which I had referred to your lordship, has been quoted. And then in para 17, the apex court clearly says, we are in respectful agreement with the aforesaid statement of law. Meaning thereby that para 6, which I had pointed out, with the strangers being permitted to file an application under order 21 rule 97, has again been, and this is a 3 judges bench judgment here, watching this particular.
Silver line.
Yes. Sir. Other 2 judgments which I had referred are 2 judges bench, but this is a 3 judges bench, but Brahmadar Chaudhary has been quoted, para 6 has been quoted. In 2020, para 9 was quoted. In this 3 judges bench, para 6 of Brahmadar Chaudhary has been quoted, and both the courts, apex courts in the subsequent judgment has reiterated what your lordship had held, that any person's means, even a stranger, will fall within the ambit of that. So the trial court's observation allowing the stranger, admitted stranger.
In another case,
maintain
that
an
is,
application was rightly held.
in another case, that is Srinath versus Rajesh.
Yes.
1998 4 SSA 543.
Yes.
There it is stated that any person, it includes all person resisting the delivery of possession, comma, claiming right in the property.
I will come to that. Let him finish first.
And 1998 4 SCC 5 43, which your lordship says Seshan's case.
Srinath case.
Yes, which had been referred to in 2020. Your lordship will find in para 10, it has, this is the judgment. Para 10, the second, just before para 11, your lordship, the next, the last 5 lines, 7 lines, we find, your lordship, in page 549, your lordship.
Got it.
We find the expression any persons under clause 1 is used deliberately to widen the scope of power so that the executive court could adjudicate the claims pleading any such application under Order 21 Rule 97. Thus, by the use of the word any person, it includes all persons registering the delivery of possessions claiming right in the property, even those not bound by the decree, including tenants and other persons claiming right on their own, including them. So this is the ratio that is there.
Yes, Mr. Chaudhary.
Lordship, my friend has taken enough pains to elaborate on the decisions. Let us, Lordship, come to page 130 for a moment of the
131.
130 of the review petition, Lordship. That is para 6, which your Lordship has quoted, of Brahmadeva.
Yes.
Brahmadeva. Now, Lordship, in Brahmadeva, Lordship will just remember the appellant was not the decree holder. The appellant was a resistor. It is very clear from the opening of the sentence. On the undisputed facts on record, it has therefore to be held that because of the resistance or obstruction offered by the appellant, amongst others, on 28/4/1991, the application moved by the respondent decree holder. Here the respondent was the decree holder. On 6/5/91 was necessarily to be one falling within the scope and ambit of Order 21 Rule 97. It is pertinent to note that the resistance and or obstruction to possession of immovable property as contemplated by Order 21 Rule 97 could have been offered by any person. The words any person as contemplated by Order 21 Rule 97 Subrule 1 are comprehensive enough to include, apart from the judgment debtor, anyone claiming through him, even persons claiming independently, and who would therefore be total strangers to the decree. Now, if your Lordship will see the statute for a moment, let us, I'm just reading out. 97(1), where the holder of a decree, for possession of immovable property. So we have to understand Brahmadeva in the context of Order 21 Rule 97. Where the holder of a decree for possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person. Now the holder of a decree is resisted or obstructed by any person obtaining possession of the property. He may make an application, that there's a comma. He may make an application to the court complaining of such resistance. Now, who will make the application? It is the decree holder. Just because in the case of Brahmadeva, it was the respondent who was the decree holder. Lordship will have to understand it in that context. Now, Lordship, I'm not for a moment saying that my friend does not have a right. My friend has a right. That is under Rule 99.
Mm,
That is under Rule 99. If he is dispossessed,
mm,
let us see 99 for a moment.
mm, mm,
Where any person other than the judgment debtor is dispossessed of immovable property by the holder of a decree for possession of such property, or where such property has been sold in execution of a decree by the purchaser thereof, he may make an application to the court complaining of such dispossession. Now, this is a stage where the property is again restored to him. This is a stage where the property, once he is dispossessed, suppose my friend is dispossessed, this is a stage where the property is again restored to him. That is what the Supreme Court has clarified.
mm,
Now, here is a case where I go for an execution of a decree.
mm,
He is not yet dispossessed.
mm,
He files an application under Order 97, and the Supreme Court says the application under Order 97 is maintainable only when it is filed by a decree holder, which I am going to show by the subsequent decisions. This decision is also in my favor. Here, Lordship will have to understand that here the appellant was not the decree holder.
mm,
It was the respondent who was the decree holder.
mm,
Now, in the same, if your Lordship will come to page 131, the quoted portion of the same judgment
mm,
of paragraph 9.
mm,
Lordship, below last 3 lines,
mm,
Order 21, Rule 97 deals with a stage which is prior to actual execution of the decree for possession, wherein the grievance of the obstructionist can be adjudicated upon before actual delivery of possession by the decree holder. Now, it is very apparent from this that it is the decree holder who will file the application. While Order 21, Rule 99, on the other hand, deals with subsequent stage in the execution proceedings where a stranger claiming any right, title, and interest in the decretal property might have got actually dispossessed. It might be the case of my friend later on, and claims restoration of possession on adjudication of his independent right, title, and interest, because the interest of the judgment debtor. This is perhaps where he can come in, not under Rule 97, but under Rule 99. If he is dispossessed and thereafter he seeks a restoration, then perhaps he can come in, but not now. In so far as, Lordship, the decisions which I have cited, Lordship, are the same propositions which have been laid down in Brahmadev, because Brahmadev, Lordship, has to construe in the light that the appellant was not the decree holder. Then Silver Line is on the same context. It goes in the same context. And I have got another decision of 2022 in the case of Sriram Housing Finance versus Umesh Mishra, where Silver Line has also been referred. Another case of 2020 has also been referred. I would take your Lordship to page 7 of that judgment, Lordship. If I may just read. From bare reading of the aforesaid provisions, it is clear that Order 21, Rule 97 deals with resistance or obstruction to possession of immovable property by any person obtaining possession of the property against the decree holder. So, it empowers the decree holder to make an application complaining about such resistance or obstruction. This makes it very clear. Here I am the decree holder. I ought to have made an application. It empowers the decree holder to make an application complaining of such resistance or obstruction. On the other hand, Rule 99 of Order 21 deals with the right of any person other than the judgment debtor who is dispossessed by the holder of a decree for possession of such property, or in case where such property is sold in furtherance of an execution of decree. The said provision vests any person with a right to make an application complaining about such dispossession of immovable property in the manner prescribed above. Now, if your lordship will come to paragraph 15. On conjoint reading of the aforesaid provisions, it can be observed that under Rule 97, it is only the decree holder who is entitled to make an application in case where he is offered resistance or obstruction by any person. In the present case, as admitted by the appellant itself, it is a bona fide purchaser of property and not the decree holder. So it goes on under the line. So the application under Order 97, Order 21, Rule 97 is maintainable only when the decree holder makes an application. There is no dispute about the propositions laid down by the Honorable Supreme Court, even in the case referred by your lordship, but that case was the other way around. The appellant was not the decree holder. He has got a right. I am not for a moment saying he does not have any right. He has got a right if he is dispossessed. At that stage, it will come, not now, lordship. That is my humble submission, lordship.
Lordship, again, this contention with my learned colleague has already been taken care of, Brahmada. I'll just read out
Yes, it is there.
this proposition that I can only come under Order 21 Rule 99 has already been decided in para 9 that this is a stage which cannot be taken care of because it goes against natural. I'll take, Your Lordship, kindly take up para 9 again. And para 9, if I may read out, because it is a lengthy para, but Your Lordship may have to go through it. Why I'm taking that?
Okay, all right.
Para 9 of Brahmadev Chaudhary. I'll just read out. In short, the aforesaid statutory provision of Order 21 laid down a complete code for resolving all disputes of execution for possession and whose attempt in executing is made with rough weather. Once resistance is offered by a purported stranger to the decree and which comes to the notice by the executing court as well as by the decree holder, the remedy available to the decree holder on such an obligation is only under Order 21, Rule 97. Rule 1, and he cannot bypass this possession under Order 135 with the help of this. Now, once Your Lordship, once such an obstruction is on the record of the executing court, it is difficult to appreciate how the executing court can tell the obstructionist that he must first lose possession and then only has his remedy to move an application under Order 21 Rule 99 and pray for restoration of possession. The High Court, by the impugned order and judgment, has taken the view that only remedy available to a stranger to a decree who claims an independent right or interest is to go by Order 21 Rule 99, which proposition my learned colleague is purporting there. This view of the High Court on the aforesaid statutory claim scheme is clearly unsustainable. It is easy to visualize that a stranger to a decree who claims an independent right and interest in the decree can offer his resistance before getting actually disposed. He can actually agitate his grievance and claim for adjudication of his independent right, title and interest on the decreed property even after losing possession as per this. Order 21 deals with a stage which is prior to the actual expression of the decree for possession, wherein the grievance of the obstructionist can be adjudicated before such actual delivery of possession of the decree holder. While Order 21 Rule 99, on the other hand, deals with the subsequent stage of the executing proceeding, whereas stranger claims any right, title, and interest in the decree might get actual dispossessed and claim restoration of possession on adjudication of his independent right, title, and interest. The interest of the judgment debtor. Both these types of inquiries in connection with the right, title, and interest of a stranger to a decree are clearly contemplated in the aforesaid scheme of Order 21. And it is not as if that such a stranger to a decree can come to the picture only at the final stage after losing possession and not before. if he is vigilant enough to raise his obstruction before the warrant or for possession gets actually executed against him. With respect, the High Court has totally ignored the scheme of Order 21, Rule 97 in this connection by taking the view that the only remedy for a stranger to a decision is under Order 21, Rule 99, and he has no locus to get adjudication of his claim prior to actual delivery of possession to the decree holder to the executing proceeding. The view taken by the High Court in this contention also results in patent breach of principle of natural justice, as the obstruction is alleged to have an independent right and interest in the decretal property and who is admittedly not a party to the decree, even though makes a grievance right at the time before the warrant for execution is actually executed, would be told off the gate, and his grievance would not be considered for her on merit. He would be thrown off lock, stock, and barrel by the use of police force by the decree holder. That would obviously result in irreparable injury to such obstruction, whose grievance would go overboard without being considered on merit, and such obstruction would be considered totally unheard. Such an order of executing court therefore would fall also on the ground of non-compliance with basic principle of natural justice. On the contrary, statutory scheme emphasized under Order 21 Rule 97, as discussed earlier, clearly guards against such a pitfall and provides a statutory remedy. Now, this is important, both to the decree holder as well as the obstruction to have their respective say in the manner and to get proper adjudication before, this two words, both and before the executing court, and it is the adjudication which subject to the hierarchy of appeal would remain binding between the parties to such proceeding, and separate suits would be heard with a view to seeing that the multiplicity of proceedings and the parallel proceedings are avoided, and the gamut laid down in Order 21 Rule 97 to 103 would remain a complete court and the sole remedy for the parties concerned to have their defense once and for adjudicating themselves. So my learned colleagues' contention that I can come only when I am dispossessed had already been answered by this Brahmado, that it says that if that stage is to be given, then it becomes a principal violation of natural justice. So both the parties, the decree holder as well as the obstructionist, either he is a stranger or a party to a decree, can raise an application under Order 21 Rule 97. And the executing court will have to consider the same and pass appropriate orders, which this appropriate order was passed against which. So my humble submission, my learned colleagues' contention that I can come only under Order 21 Rule 99 is no longer res integra. It is settled by the judgment he is referred to, Your Lordship, which has been subsequently reiterated by the Apex Court time and again. So my humble submission, Your Lordship, or the application which was filed was rightly allowed by the trial court, and Your Lordship had rightly upheld the trial court's verdict by the order which is now under review by my learned colleague, Your Lordship. That is my humble submission.
Insofar as the reiteration is concerned, Lordship, the reiteration is so far as who can maintain an application under Order 21 Rule 97. On the day when the judgment was rendered by Your Lordship, there was a decision of the Honorable Supreme Court which held that an application can be maintained only by a decree holder, which I have just given of 2022. The silver line is also there. Now, when that judgment was there, and that judgment perhaps for something was not placed before Your Lordship, now that is also a very good ground.
No, Brahmadev Chaudhary is prior in time.
Brahmadev Chaudhary is prior in time. Now there was a later judgment on the same point.
Maybe which one will follow?
Now there was a later judgment.
No.
Yes.
This Pronoy Sethi's case, constitutional bench decision, the earlier one.
I would leave that to Your Lordship, but my submission would be that when there was a decision of the Honorable Supreme Court, which was there, on the day when this particular
No,
judgment was
that
pronounced.
later decision would be par in curiam because earlier it was settled. And there is also another three judge bench decision on this point. So this later judgment of 2022,
Lordship.
that would not come into your aid.
Uh,
Okay, we'll pass the order. Yes, next item.
Section 31, appeal of president. Please, please.
Mr. Roman, take a date from him. We have already called the matter and you have been found absent at that time.
This is an implementing petition, my lord.
Pardon?
As per number 6 died, my lord.
Pardon?
And it's implement petition, my lord.
Impleadment petition.
As per number 6 died, my lord. Even, my lord, he died, my lord. Before, my lord, filing the review petition, my lord, here. That's why, my lord, it's not, my lord, substitute petition, this is, my lord, implementing petition. As per number 6 died, my lord.
Yes, any objection or any incision? No objection. Heard Mr. Khomikor, learned counsel for the applicant, and Mr. Pudder, learned counsel for the respondent. This application under order 1, rule 10, within bracket 2, read section 151 of the Code of Civil Procedure is referred by the applicant for implement of legal heirs of respondent.
That's number 6.
Respondent number 6. Respondent number 6. Mr. Khomikor, learned counsel for the applicant, submits that respondent number 6 died during the pendency of the execution case on 19/5/20. 2025 or what? Paragraph number 1.
My lord.
Last
19/5/2000.
last line, last. When he died?
I have that.
2000.
I'm sorry, my lord, 2002.
Nineteen five 2020.
2022.
2020.
Okay, 2020. 2020. And as such, his legal representatives are required to be brought on record. Brought on record in the CRP number
297.
297 of 2025. Mr. Poddar, learned counsel for the opposite party, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The legal representative of the respondent number 6 shall be implemented in CRP IO number 297 of 2025. In view of the order passed in this IA, Mr. Khomikor, learned counsel for the petitioner, shall file amended cause title of the CRP IO number 297 of 2025 within a period of 1 week from today. Please the matter. Take a date from him.
25 or 27, my lord. It will also convenience.
Mr. Khomikor, your name is not in the cause list.
I have filed local now.
When?
Yesterday I have filed local now.
When did you file?
Yesterday.
Yesterday. Mr. Khomikor, learned counsel for the applicant, submits that his name has not been reflected in the cause list, though he has filed lokalatnama yesterday. Rest shall do the needful in this regard.
But there's an interim order that may be completed.
Interim order passed in the CRP IO numbers so shall continue.
Deep level.
34.
Your Lordship, I'm appearing on behalf of H. Gupta. We have filed this application for condonation of delay of 22 days. As on 30/5/24, and we have challenged the
Okay, heard miss, your name please?
PR Chaudhary.
Learned counsel appearing on behalf of Mr. S. Gupta, learned conducting counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 22 days in preferring connected civil revision petition against the impugned judgment and order dated 9/2/2024 passed in Miss Appeal case number 17 of 2023 passed by the learned additional session judge number 2 FTC Tinsukia in connection with Tinsukia. Let notice be issued to the opposite party returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Please after 4 weeks.
Obliged.
May it please your lordship. Your lordship, this IA is for condonation of delay of 77 days in preferring the connected second appeal.
Okay. Heard, Mr.
AI Ahmed.
KI. AI or KI?
AI.
AI Ahmed, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is prepared by the applicant for condonation of delay of 77 days in preparing regular second appeal against the judgment and decree dated
3/7/2025.
3/7/2025 passed by the learned
Court of Civil Judge Senior Division at Borpeta.
by the Court of Learned Civil Judge Senior Division Borpeta in title appeal number 29 of 2017. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Place the matter after 4 weeks.
Deeply obliged.
Item 42.
May it please, my lord. My lord, steps to speed post had been taken on 24th, 24 to 26. However, inadvertently, my lord, usual steps to usual process has not been taken. Your my lord may grant me some time to do the same.
Heard, Mr. Chaudhary,
Yes, my lord.
learned counsel for the applicant and you. Learned counsel for the respondent number 123. 123. Mr. Chaudhary submits that he has taken step upon the respondent number 4, 5, 6, and 7 by speed post. And the office note dated 24/2/2026 indicates that the said notices were issued only on 24/2/2026. Mr. Chaudhary further submits that he has not taken step upon the aforementioned respondent by usual process, and he prays for granting him some time to take step upon the aforementioned respondent by usual process. By usual process, pair allowed. Rest shall list the matter after 4 weeks. After 4 weeks. In the meantime, rest shall also track the consignment and put up an office note in respect of the notice issued to the respondent number 4, 5, 6, and 7 by speed post.
Deeply obliged, my lord.
Item for admission. Item number 2. Authorization.
May I please, Your Honor? Your Honor, Standing Council of Elementary Education Department, Your Honor.
Pardon?
Elementary Education Department, Your Honor. Informed my senior, Your Honor, they want another 2 weeks time for obtaining instruction, Your Honor.
Another date.
Another, Your Honor, another 2 weeks time. So matter may be fixed after 2 weeks, Your Honor.
Mr. Your name, please?
J.I. Mundal.
Learned counsel appearing on behalf of Mr. Behme Islam. And price for listing the matter after 2 weeks. They are allowed. Have a nice day.
কোন তারিখে আছে মেইন পেপারটা?
Why read the short?
বই পরে দেবে।
From the record in this case. Got the record in this case.
You brought the record.
Yes.
Okay.
Directed me to bring the record. The record for both these matters. So I've got it with me. And
No. My lord, if I remember correctly, this court did not ask him to get the record. While argument was going on, in respect of a dice data, my friend wanted to bring the record to show before my lord some discrepancy, my lord. And I think, yes, I remember exactly. That is the thing. And then orders are there. And we said, if your lordship remembers, that it was nobody's case. I don't know what kind of a record is required. Let him get the record.
absolutely,
So-
not, my lord. My lord, the fact of the matter remains that, my lord, that we had filed our affidavit, my lord. If we had filed our affidavit, my lord, the court, my lord, there was some, my lord, the confusion regarding the, my lord, the date of joining also, my lord, because in fact, the petitioner in the second case had said that he was senior in age. So all the confusion was there. So therefore, my lord, the record was called for. So therefore, I have got it.
Okay.
So I had not asked him, because I have already filed my affidavit. Why will I ask for record?
There was a direction from this court
Yes, ma'am.
in the order dated 19/11/2020.
Yes.
Exactly.
Yes.
There was-
Okay, we will resume after 5 minutes.
Fine.
জানো নহয় কিয় দিছে নাৰাখে।
Yes. So, the argument of petitioner side completed.
No, my side is complete. Item number so far as 3 is concerned. I have completed.
Okay, okay.
I'm there for item number 3 as a respondent and item number 4 as a petitioner. My lord, I think, my lord, in this case, if my lord agrees, my lord, I think getting everything ready, and I think possibly the matter has already been 3 months, 3-4 months have gone.
Hmm.
I think in last shot, I think once we have to freshen up this both sides, my lord, so as to enable the honorable court to adjudicate the matter and to see what were the arguments earlier made and all this thing.
Lordship, there was a confusion regarding who, Lordship will first see the triple teacher ratio as per the RT Act, my lord. Lordship has the RT Act, 5 teachers were supposed to be there. And as per affidavit, there was confusion who should be the other person in terms of the language teacher. So my lord, I have got the IS data as well as my lord, if your lordship sees the green part, there, your lordship sees the date of joining of the my lord, people, my lord, Abu Tahir Sheikh, my lord. His date of joining is 6/2/96. Kindly note that. He's a language teacher. Abu Tahir Sheikh. Abu Tahir Sheikh, you got
Yes, yes.
then the date of joining. Then second is my lord, Mehboob Alam Ahmad. Sikandar Ali. Sikandar Ali. He's 1/1/1990. Then Qasim Ali is 1/1/1990.
Where it is mentioned?
My lord, in the green, there's a green page. Yes, can you see one? The date of joining. Third column, qualification, then date of joining.
Yes.
And my lord will see Abdul Karim Mullah is 5/10/2010. 5/10/2010. So he's junior. Now lordship will see the after that one the pink marker.
My lord, without disturbing, I'll say some confusion. I'm the founder teacher.
First, let him come.
Yes, yes.
You will get a chance to rebut the same.
But as I'm saying, as per record, record Abdul Karim Mullah is qualification is HS pass and he's 5/10/2010. As per the record. Then so that automatically he's the junior most fellow. Fellowship seats. As per record. And thereafter, if fellowship flips the page, there is the direct data thing, So as per this thing, social science teacher is Musharraf Hussain. So he has got as per social science. And my lord, 3 language teachers, my lord. Because pupil teacher ratio was 170, my lord. So accordingly, five teachers have been given. So as per affidavit, my lord. As per affidavit, in the final affidavit, page 91, and page 91 of the affidavit, we have the people who have been 176. In view of the above, as per recommendation of the DSC, the following teachers are eligible for provincial action. These names have been finally given. That is Abu Tahir Sheikh at page 91. Page 91. Abu Tahir Sheikh, language. The lordship will check again. Abu Tahir Sheikh. Abu Tahir Sheikh has joined on. The lordship will mark it, my lord. 6/2/96. 6th of February 1996. So he has joined on 6th of February 1996. He's a language teacher. Then Sikandar Ali. He's also a language teacher, my lord. He has joined on 1/1/1990. He is there, my lord. Then Mehboob Alam Ahmad, my lord, automatically he is maths and science. So he is the only candidate for maths and science. He is also, my lord, 1/3/2006. So they cannot claim for maths and science. Next is Qasim Ali. Qasim Ali is 1/1/1990. And then thereafter Musharraf Hussain. He's a social science teacher. He's social science man. Social science also they cannot claim because they're language men. So the bone of contention was between the language teachers. Gets final because only 5 teachers can be selected as per the pupil teacher ratio. Also we'll see the pupil teacher ratio. We'll get it in the RTE Act, minor. Fellowship at the RTE Act. RTE Act.
Is it available in the manual?
Yeah. Schedule of the RTE Act. The RTE Act, the schedule, section 19 and 25.
Yes.
We'll see between 121 to 200. It is 5 teachers. 5 teachers. The schedule of the RTE. Section 19 and 25. Serial number of teachers for first class to 5th class. And on the admitted children, my lord, and my lord, between 120 to 200, that is 5 teachers. So out of my lord, 5 teachers, 3 out here are language teachers, and my lord, 2 are, one is maths and science, and the other one is Mosharaf Hussain, who is social science. So Mehboob Ali Ahmad and Mosharaf Hussain, they were not qualified as maths and science and social science. And from the rest of the 3, my lord, these 3 have been selected because they are senior to my lord, the Abdul Qasim Mullah, Abdul Karim Mullah. So that is the case, my lord, that's why, my lord, as per affidavit at page 91, at page 91, we have selected, in view of the above, as per recommendation of the DSC Dhubri, the following teachers are eligible for provincialization of services as tutor under the provision of the 17 Act at Kalapakani, so school. Sakatun Academy School. So these 5 teachers were recommended because of that. So that is the, my lord, that is how we are established. 3 teachers because they are senior to the petitioner. In who's the second case, Abdul Karim Mullah. That is the record whatever I'm submitting. The fellowship. Since Abdul Karim Mullah is 2010, my Abdul Karim Mullah is HS pass and he's 5/10/2010. So he's junior in date of join. Whereas Abdul Tahir is senior most, sorry, not senior most, 1996 he's joined, 6 to 19. Sikandar Ali is 1/1/1990. Mehboob Alam is a maths and science teacher. Tasnim Ali is 1/1/1990. So these are the big. This is my assumption.
Wrong. Absolutely wrong. Totally wrong. Okay. Yes, anything to reply?
My lord, there is somewhere some confusion, my lord. It is absolutely wrong that my date of appointment is 2010. In fact, if we take this first item, which my lord is now referring, I think 4498 of 2024.
Yes.
So it is Musharraf Hussain versus me indirectly. If he can say that I'm 2010, I'll go out of the court, my lord. Now, let get this position cleared, my lord. Would your lordship be pleased to see item number 4, my lord. That is my case. And only to show the date, my lord, nothing else.
Yes.
My lord, Annexure 1, page 24. Page 24, my lord. This is my appointment order, 15/12/1989.
Yes.
My lord, next, Annexure 2 is my joining 1/1/1990, my lord. In my reply, where? In first case. Musharraf. My lord, would your lordship be pleased to see that in Musharraf case, that's item number 3. My lord, my affidavit in reply is there. That is page 124 to 134 in the index page.
Yes.
My lord, would your lordship be pleased to see page 135?
Yes.
135, that is the appendix 1.
Mm.
And I would like to also request my friend, my Musharraf, on behalf of Musharraf, to also see this if there is anything wrong. Over here, if your lordship looks, my name is serial number 5,
Mm.
Abdul Karim Mullah.
Mm.
My lord got it.
Mm.
Abdul Karim Mullah is the respondent number 9. And it is prepared by respondent number 8 herein, my lord. Respondent number 8 prepared this while submitting before the authority, my lord.
Mm.
Abdul Karim Mullah, my date of joining is 1/1/1990. And admittedly, my lord, I am the founder teacher of that school.
Mm.
So I don't know, somewhere something is wrong. That 2010. I don't know how they got it. But another leg of argument, what my friend has just said, would your lordship be pleased to see this my lord, book again, my lord,
Mm.
kindly.
Mm.
That is
Schedule.
yes, my lord, schedule directly. Schedule page 2 কিমান আছিল ন?
28. 28.
My lord, 28, page 28,
Yes.
RTF.
Yes.
So what my friend has said regarding that between 121 to 200, 5 teachers, I think that was projected, my friend. Huh? 8 to 9, 5. I think that was projected by my friend, my lord. That will not apply over here because this is in respect of class 1 to 5. That serial number B is applicable in the present case because our is a upper primary school.
Mm.
So over here, my lord, if your lordship notes down, my lord, without going into the much confusion as on date,
Mm.
my lord, left hand side for 6th class to 8th class, my lord got it.
Mm.
Then serial number 1, that is the first 3 teachers you have to have in a school. My lord, 2, your lordship will see,
Mm.
at least 1 teacher for every 35 children. So what they are saying, exactly it is 5. 5 point something, but it will come to 5.
Mm.
It is 176 from their own statement, from their record.
Mm.
170. It's still 5. Now, my lord, 3.
Mm. Mm.
That is the most important thing, my lord. If it is done, then there will be there will no in fact no argument from any side. Everybody will be happy. Where admission of children is above 100, a full-time head teacher. So it becomes 6.
Mm.
5 plus 1, 6.
Mm.
That is lacking, my lord. Number 1, I'm the senior most over here. I think I don't know what is the confusion over here. Number 2, this RT Act has to be followed. If they follow it, then with their own statement, if it is 176 or 171 student, it still comes to divided by 35, it comes to 5. So 5 teachers are there. School will invariably will have 1 head teacher if the enrollment is more than 100. So ultimately 6 teachers. Over here, though I come serial number 3, but what my friend has suggested that because my 2010 written, I was not considered. Your lordship may not have to go into that aspect also. If they fulfill this schedule of 19 and 25, and they go for 6 teachers, then everybody, I think, possibly all the sides will be happy, my lord.
My lord, that regarding the second part, my lord, it is where admission of children is above 100, a full-time head teacher. Head teacher is already there, my lord. There's the head teacher who's here, who's I think the other respondent. Abdul Tahir.
No head teacher is there.
My lord, there's no mention of, my lord, an additional teacher. Kindly see, my lord. Part-time instructors for art education, health and physical education, work education. They are not, my lord, for those, it's not mentioned anywhere. One more teacher. And my lord, for the year 2017, if your lordship sees the pupilization ratio, that time for 1 year, I think it was 170. Later on, it declined because it has come down to 130 something. Your lordship sees the data. The ratio has to be seen also, the pupilization ratio of every year. 1 year cannot be taken and my lord, 6 teachers stated. So that also is also thing. So the argument which my learned senior has said, made, my lord, is agreed upon to a certain level, my lord, but not the whole thing is not, my lord, the full gospel. That this both the
No,
first part, my lord, when
Mr.
five
Fukan, from this page number 11 of your file, where it is mentioned that Abu Tahir Sheikh is the headmaster, full-time headmaster.
my lord,
One
his
SM
lordship
is
sees the lordship's sees the signature. If your
No, no,
lordship
yes.
checks, if your lordship checks now the affidavit which my learned senior had shown at page 135. Page 135. Just now my senior had mentioned this particular, he had shown the educational and professional qualification of teachers at page 135. The affidavit which my senior had filed.
That is before provincialization, my
Just,
friend.
135.
He has been provincialized as a tutor. School doesn't have a headmaster. Let the facts get right.
Kindly see the signature.
And how he said that there are less students in the next year, the judgment will say that there are 236 students. It is increased.
My lord, kindly see the.
Let have the factual position correct.
Lordship will see page 135 once. 135, Lordship will see, and he has shown this document. This document. Signature of
No,
headmaster.
if he is appointed as tutor, then
that is a different aspect. But he said there is no this thing. But going by our.
What is different aspect? I'm saying there is no headmaster. Respond number 8 is over here. Your lordship may ask him whether he is the headmaster or the tutor. And my lord, would your lordship be pleased to see page 35 once of this Musharraf case, my lord, item number 3.
Lordship will go by the.
Only once, my lord. Yes.
page number?
Page number 35, my lord.
Yes.
Paragraph 9. This is the part of the earlier, my lord, judgment, my lord, in this case. This I'm showing because my friend has said from 176 it declined. How can he make this kind of a statement when the order itself, it says it is 236 now after that?
The records. For the records.
Okay.
Lordship will go by the rule, my lord. We have given, my lord, between 100 to between 121 to 200, my lord. That is the explanation which I have given, my lord. That is 5 teachers, my lord. And if your lordship sees the dice data which I marked there, that is the record, my lord, which I have produced. There, my lord, your lordship will see the date of joining of Abdul Qasim Mullah.
Abdul Karim.
Mullah, my lord.
Yeah.
This is 5/10/2010 and his HS pass. So that itself shows that he's Indian. That is the submission which I have made.
I don't know why he is still arguing that
Okay,
case. I'm
okay.
saying there is something wrong. I'm the founder teacher.
Okay.
That is the as per records I'm going.
My lord, 2009 and 10, would your lordship be pleased to see the dice code, my lord?
Okay. Furnish to him. heard Mr. Deca, learned counsel for the petitioner in WPC number 4498
Yes, my lord, 498.
2024, and Mr. Devan, learned counsel for the respondent number, no, for the petitioner in WPC number 4628 of 2023, and Mr. Pokon, learned standing counsel for the respondent in Elementary Education Department. And Mr. Das, for the respondent number,
It's just maybe
H das for respondent number
8.
8.
Eight.
Respondent number 8.
In item 3, my lord,
Yes, you are for respondent number
I'm 7. In
7.
item 3 and item 4, I'm the petitioner.
Respondent number 7. Argument concluded, judgment reserved.
My lord, I just, for one minute, my lord, I've just given a dice code of 2009 and 10. Would your lordship,
Okay.
my lord, would your lordship to please to see only once, my lord? May I have to mark it?
Mm.
Serial number 3.
Yes.
Serial number 3. In the dice itself, it's shown that I have joined the school in the year 1990.
Okay. We'll see.
I have also recorded.
Okay.
Deeply obliged.
Okay. Okay.
আজকে আমার reply. My lord, today I understand it is for our reply.
Yes.
Or if the other side has got anything to say, they may say, then I'll reply.
We have not opened our mouth till now.
Oh, then it's okay. Then they should reply, Miller. They should, make their part, then I'll give my reply.
No, they have already completed.
We have not completed.
He says he have not even opened the mouth.
Okay.
But very interesting thing I would like to point out today.
Okay.
For that, I would like to request this honorable court that I may be allowed to file a one-page short affidavit. Additionally, these facts I had, day before yesterday, I saw time because I had some queries in my mind. I got all the information.
Hmm.
So why I want this additional, why I'm making that. People kindly come to is. Lordship will kindly take the petition 3807.
আমার ফোনে নেই? কোথায়? এক করা।
That's 3807. Yes.
আমি এখানে ক্লিক করলো।
Yes, 3807.
Lordship will kindly come to page 39, the writ petition, the clause titles. At the very first page, Lordship will kindly see the district is Hailakandi. The first page at the top. So this case is basically related to Hailakandi. Then Lordship will kindly see the petitioner's name from serial number 1. They are all from Hailakandi. Except few from Kachar and few are from Nagaon. There are about exact number, I just keep one. Total 143 petitioners. So if you look at 143, they are from Karimganj. Kebanel are from Karimganj. And you are from Kachar, page 74, serial number 110. They are from Kachar. And also Lordship will find you are from Nagaon. So 143 petitioners are from various districts. Majority are from Hailakandi. Substantial number from Kachar. Few are from Nagaon and some are from Karimganj. Now Lordship will kindly come to the advertisement. At page 94. Here, may I read this advertisement of 30th June 2017. In view to support, strengthen and improve the quality of elementary education in the state of Assam in compliance of the Rights to Education Act 2009. And in view to ensure availability of teachers in lower primary and upper primary schools of Assam, especially in high pupil ratio teaching ratio PTR schools of remote and isolated areas. Page 58 also. 68, I'm sorry, the advertisement.
Okay.
With a view to, this is 30th June 2017. With a view to support, strengthen and improve the quality of elementary education in the state of Assam in compliance of the RTA Act, with a view to ensure availability of teachers in LP and upper primary schools, especially in high pupil teachers ratio of remote and isolated areas, subject to approval of post-based roster register from WPT BC department, personnel department. Online applications are hereby invited in prescribed format from LP and UP teachers eligibility test or CTET qualified candidates who are citizens of India as defined under Article 5 to 8 of the Constitution of India and permanent residents of Assam for filling up of the following position of assistant teachers at lower primary and upper primary school on contractual basis under the Sarva Shiksha Abhiyan Assam as shown in the tables below. The category-wise number of vacancy may increase or decrease after obtaining approval from the concerned department. So, at the very beginning, it is said that the number of vacancies may increase or decrease after obtaining approval from the concerned department. In the advertisement, first paragraph, two departments are already indicated. One is WPT and BC department, and other is the personnel department, which actually controls the employment part. The Gazette, it says the approval of the education department. The Gazette notification dated 13/7/2017 comes relaxation. This I will come later on. Now, Lordship, we see district-wise, category-wise vacancy positions in lower primary schools. Serial number 1, Borpeta, 620, Biswanath, 125. Lordship will kindly come to see Kachar, 344. At serial number 4, Hailakandi at serial number 12, it is 49. And Karimganj 17, it is 567. Total in lower primary is 5854. Then identically in upper primary school, science teachers, Kachar is at serial number 68. Karimganj at serial number 1736. Total is 911. And next page, upper primary maths and science. Karimganj at serial number 1626. Kachar at serial number 424. Then Hailakandi at serial number 11-2. These district-wise vacancy positions are indicated because it is contemplated under this advertisement. District-wise selection will take place. It is not a state-wise centralized selection process. How? Lordship will kindly see the criteria. The same page. Criteria, serial number 1 I am skipping, 2 I am skipping, 3. Online applications and documents submitted by the candidates will be verified along with their original testimonials in the respective districts by the district level screening and verification committee. The district-wise detailed schedule for verification of documents will be notified in the notice board of the Office of the District Mission Coordinator, SSA, concerned. No TAT admissible for appearing and verification process. And now Lordship will kindly come to 7A. A candidate can apply only for one district mentioned above. So what we can understand from these two clauses that if candidate, suppose I want to apply, I have to apply in only one district out of all the districts which are named in the advertisement. And each district has a district level selection committee for verification of the document. There is no written test. It is not a centralized selection or recruitment process. It is an individual district-wise recruitment process. Although advertisement was same, but very clearly it has been said a candidate can apply only for one district. That means if I apply for Kamrup Metro, I cannot aspire to get a post in Hailakandi district or Kachar district. So therefore, my humble submission is that their whole case that they are aggrieved because if we look at the total number of vacancies which has been indicated, it comes to around 7,042. So if we add up all this, it will be around 7,042 posts were advertised, but district-wise, the numbers are given. So these are all separate and mutually exclusive recruitment process. It has no bearing of the selection of Nagaon with the selection of Sibsagar or Dibrugarh with Dhemaji. All are individual selection process. Because each district is having a district level scrutiny committee or selection committee. And there is no scope for state level committee, unlike the case which we were doing yesterday, Lord. So that is the end of the story. That after the district level selection committee, they will give the appointment orders to the directorate. So if we look at the total number of vacancies is 7042 and with a caveat that number of vacancies may go up or it can get decreased also. Line says the category wise number of vacancies may increase or decrease after obtaining approval of the concerned departments. Now, their prayer lordship will kindly come to page.
So this column is mentioned in which part of
Which-
the advertisement?
Which one, lordship? That increase or decrease?
Yes, yes.
The page number 58. First paragraph, last line. Category wise number of vacancy may increase or decrease after obtaining approval from concerned departments.
Okay.
Have lordship got it?
Yes.
So now there are 4 districts.
Mm.
It will be a different story how 4 district elections are combined in one repetition. That I will argue. That we cannot amalgamate causes of action of various recruitment processes. That is one. But what information I have got, so far as Kachar district is concerned, where majority of the petitioners, there is no increase of the number of posts, which has been notified here. With a caveat, it may go up or it may go down. The number of recruitment which has taken place in Kachar is same. Same with Nagaon. So therefore, lordship will kindly give me a day's time now to file because this is a major bearing. Whatever case they have projected, they have all other grounds I will argue without participating in the recruitment, how they can challenge all these arguments are in my hand. But one important thing is that if the advertisement is for 100 posts in Kachar and the total recruitment is 100, so no cause of action has arisen, even if you assume that their repetition is maintainable. So that factual aspect in our affidavit earlier, it was not highlighted. That's why I took, when I prepared the case day before yesterday, I found that this is very critical information. And therefore, lordship was kind enough to give me the time till today to argue the case. And we have just received the information from all the districts with the whole chart. What was the notified vacancy with that caveat of going up and down, the exact number of recruitment that has been done.
Okay.
So lordship will maybe please to give me 1 or 2 days time, I will file the affidavit. Additional affidavit, which is a factual aspect. This cannot be covered by legal arguments.
My lord, I have a small argument. If your lordship should kindly have order dated 10/6/2019. 10/6/2019.
10/6/2019.
2019, my lord. In this writ petition only, 10th of June 2019.
Yes.
The last parameter, the petitioner submitted that they have no grievance against those 7042 TET qualified teachers appointed by SSA Assam pursuant to advertisement dated 36/27. But by appointing 11,319 number of teachers beyond the advertised post dated so and so by the SSA, the petitioners have been deprived from the right to those posts of assistant teacher under SSA, though they are TET qualified. On the next date fixed, the respondent shall place all the relevant advertisement and or corrigendum along with the copies of the newspaper in which such advertisement and corrigendum were published with regard to appointment of 11,319 number of assistant teachers on contractual basis by SSA, in addition to 7042 number of teachers engaged teachers pursuant to advertisement dated so and so. So, my lord, the affidavit should also incorporate these informations. And we are not against this 7042. We say these additional 11,000 appointments which have been made, that is per se illegal. No government on earth has such power, my lord. And the affidavit which they have filed, the reason which they have given, we have already explained why that is not sustainable. So, my lord, my humble submission is this particular requirement which this honorable court insisted, that point should also be covered in the affidavit to be filed.
Whether recruitment will sustain or the petitioner will get sustained, that lordship will take a call when we argue on the point of maintainability also.
Okay, you furnish these informations also
Yes, sir.
as required by this order.
It's not required. I can right now say that no further corrigendum was required. No further corrigendum was issued, neither it is required. The advertisement itself says, the line which lordship asked me, that the number of vacancies can go up or go down as per the approval. These are not future vacancies.
Okay, all right.
These are not future vacancies. These are not anticipated vacancies. These are existing vacancies.
Today I am not joining issues. On my reply, I'll explain everything. Let my learned friend finish, then I'll give my reply.
Okay. So we'll list the matter on Monday then.
Yes.
We'll file it. Monday I will not be available. Let it be on 8th or 11th of March. Nothing has remained, lordship. In this case, although they are asking for removal of those persons beyond 7,000 to 11,000, hardly 153 are still left.
Look, it's not a case of 7,000 to 11,000. It's a case of 11,000 only. 7,000 is already appointed.
All right. All right.
All are appointed
Okay.
and all have left the job. Only 153 are left.
Okay.
And
Okay.
on top of that, the grievance which they are raising, it is not sustainable in their district.
Okay. Heard Mr. K. N. Soduri, learned civil
11th
counsel
of May.
assisted by Mr.
RM Deca.
R.M. Deka, learned counsel for the petition. And also heard Mr. D. Soike, learned advocate general, cum senior advocate, assisted by Mr. S. Bora. Mr. Bora, you are assisting. Learned counsel. During the course of argument, Mr. Soike submits that he may be granted some time to file one additional affidavit. Where allowed.
We'll respond to that order, lordship. We'll respond, but whatever documents we have, we'll file. In fact, we have no
With,
other document,
with-
we'll say that.
With a response to the order dated
10/6/2019.
10/6/2019. 10/6/2019. Where allowed, recessal list the matter on 11th of March.
For 12, not 11, because 11 is a miscellaneous day. 10th is a hearing day, 12th is a hearing day.
Okay.
12 mil.
Well,
Highly obliged.
For bail hearing, item 7.
Was there in that opposite court in court number 23. Your lordship's order is at page 16. para 7, your lordship's last order, page 16, para 7 is the finding. My friend has come. And now notice has been issued to me to appear before them, madam. At page 22 and at page 27. And now I'm not in job. I have been dismissed. Your lordship last finding is at page 16, para 7.
Yes.
Yes, Lordship, I have gone through. It is an earlier rejected case, Lordship. In this case, the person, the informant's father and complainant, Lordship, was died on 28/3/2024. However, before his death, Lordship, on 7/1/2023, an agreement for sale was made, Lordship. And power of attorney, general power of attorney was given, Lordship. But he missed.
No, what is this? The investigation is pending now.
Investigation is pending because, Lordship, on earlier occasion, this person was found, Lordship, and investigation has stated that, Lordship, with this person, Lordship, the original forged deed was there with him, Lordship, and he is also in Lordship original RTI book, fee book also with him, Lordship.
I am not in
It is
job.
because of
I'm
that,
not in
Lordship, but the original is with him, as per Lordship, this person,
No.
investigation, Lordship. And moreover, Lordship is already aware, Lordship, into the person, the sub-register, Nirhanta, 1,000, Lordship.
My lord, if I can please.
Let him complete.
He was joined on 26/7/2023, Lordship, in Nogaf. He was not here, Lordship. And during this period, he has given this authorized this person, Lordship, to get the ID, to get the approved ID, Lordship. And during this period, he modified this, Lordship. So materials are definitely there, Lordship. And police is in charge of him. to
Yeah,
put
we should
this,
notice.
document,
No,
Lordship.
whether those original books were recovered from him.
No, Lordship, till now, he is not able to apprehend that, Lordship. But according to him, first it was thought that, Lordship, it was with the advocate, Lordship. It is not found. So from this, what Ali, Lordship, one from Ali. First it was thought that it was with him. He stated that it is with his advocate, Lordship, Dipanjali, or Dipali, Lordship.
She was given bail. Yeah,
But it is also not with her. So police is in charge of this, Lordship, whole document. Cannot get hold of this document, Lordship.
No, at what is this? The investigation is pending.
Otherwise, investigation is going on, Lordship. Other officers are also investigating, Lordship. And he was trying to apprehend for this, Lordship. This document.
Okay, you furnish the city. Yes.
My submission before your lordship is this. All these facts, whether 1,000 has given me that authority or 1,000 has given me anything, all this thing or power of attorney holder has expired. Thereafter, it was so agreement to sell was done. Now, my lord, it was rejected on that ground that incriminating materials were there. Now, my lord, the other person, the advocate, has been given, my lord, anticipatory bail. I have annexed at page 17. And now they have issued me a notice. I am not in job. I have been dismissed from service. So those documents cannot be with me. I will appear before the authority and disclose everything. Why custodial interrogation, man? I will appear. I am willing to appear, man, to disclose everything. Nothing in hide and seek.
Mr. Roy Soduri, it is the investigating authority who will determine whether your custodial interrogation is
I understand,
necessary or
madam.
not, and also by the court, not by you.
I am not asking that, my lord. What I am saying,
No,
because
you
they have placed
are
on the fact.
justifying that your custodial interrogation is not required since you have been dismissed from service.
Not only that, my lord, because I want to cooperate with the investigation. I am not placing those submissions before lordship that I am placing that investigation is not required. I want to cooperate with the investigation because the facts that has been laid down, putting all allegation with me.
No, just before few minutes you argued that your custodial interrogation is
Whether
quite
my lord-
necessary.
Because I want to cooperate with the investigation.
Okay, we will see.
And the notices have been issued to me to appear before them. Those notices I have annexed,
Go and appear before the IU.
my lord, and they will put
Who
me behind the
prevent
bar,
you?
my lord. That is there. They will put me behind the bar, my lord.
Okay, we will see. Yes, next item.
Running items 13 and 14.
Happily, the lordship.
Yes, Mr. Pusik. This report, we have never called for this report from you.
So there was an attendance register produced
Hmm.
based on which he's trying to justify that there were students
Hmm.
which warrants a opening of an additional class for getting.
No, in this contempt petition, we are concerned with compliance of the order
Yes,
passed
sir.
by the school.
They, if the lordship can see. The section members. And my affidavit also page 70. Page 60 is the order of this honorable court.
Hmm.
Page 70 are the directions. Nineteen, 20, 21, and 22 are the given operative portion. Page 70.
Page number 70,
70.
17. Paragraph number
19 may start from 19.
order is updated 21/3/2024. Okay. Which paragraph is the operating part?
My lord, 19 is the consequence of that repeating where the earlier order was set aside. And the further direction starts from page 20, paragraph 20. In view of the above fact that the order dated has been interfered with by this court, on arriving at a conclusion that the grounds assigned for rejecting the case of the petitioner hearing are clearly not sustainable, the matter now remands back to the Director Elementary Education, who would now place the case of the petitioner again before the High Power Committee and or any other committee presently in existence of considering of the case of the petitioner for provincialization in accordance with the decision of this court relating to provincialization, regularization, service of drop teachers as well as policy as contained in Office Memorandum dated 13/1/2023. Now, this was the first direction for placing it before the High Power Committee. Second direction is to the High Power Committee. The High Power Committee then shall strictly consider the case of the petitioner in terms of the Office Memorandum dated 13/1/2003. Decision of this court rendered in Tapan Chandra Das Supra. Now the next direction of consequence. In the event the High Court Committee recommends the name of the petitioner for provincialization on consideration of her case strictly by appreciating the factual position available with regard to the service rendered by the petitioner in the same school, such provincialization shall be effected with effect from the day the other similarly dropped teachers came to be regularized in their service in pursuance of the Office Memorandum dated 13/1/2003. So, if the High Court Committee takes a decision for provincialization in terms of the Office Memorandum and the earlier judgment of this Honorable Court in Tapan Kuba Supra, then the third direction would come into play, giving her the effect. Now, can you see page 72 is the Office Memorandum. These are the conditions which has to be fulfilled for
Page 72.
page 72.
Page 72. It is an additional affidavit filed by the petitioner.
Find page 72.
This is the annexer of which party?
I think case number 112, Lordship. I think case number
112.
Yes. Yes.
It is dated 13th of January 2003.
Yes.
Okay.
This is the Office Memorandum which was directed to be followed for the purpose of giving a consideration.
Okay.
Now, when can you see these are the 6 conditions criteria for adopted with retrospective effect. First is teacher must have put in at least 2 years of continuous service immediately preceding the taking over of these concerned schools by the government. The appointment of drop teachers must have been duly approved by the concerned district elementary education officer. The appointment of drop teachers by the managing committee must be commensurate with the enrollment of the students in this school at the time of provincialization.
Yes.
The school-wise norms of the number, but here Lordship can take note of this because this is the criteria which it was found that the petitioner did not fulfill. However, the minutes of the committee.
High Power Committee.
High Power.
At page number?
116.
116.
Yes. Yes.
117. This was a press consideration given after there was an observation made by your Lordship. Okay, just High Court Committee meeting dated 24/9/2025. In compliance of High Court order dated 24/9/2025 in contempt case number 353/2024. The matter was looked into afresh in the meeting dated 24/10/2025. After careful examination of the matter, the committee instructed the director to submit a detailed report as to whether the petitioner fulfills all criteria laid down in Office Memorandum dated 13/1/2003. This was the direction by the Honorable Court that while giving a consideration, this poem has to be followed. Director Elementary Education was instructed to elaborately examine the following points and submit the report at the earliest. If the school was in effect of provincialization in 2008, did the petitioner put in at least 6 years of continuous service immediately preceding the taking over by the government? Was the appointment of the petitioner by the managing committee commensurate with the enrollment of the students in the school at the time of provincialization? That is one of point number 3 of the document. Where the school-wise norms of number of sanctioned posts maintained, provincialization particulars submitted by DEO, IOS and available with the director will be used as a reference document. The same remains to be shared by the director. Regularization of service will be subject to availability of sanction post in the concerned department. The committee examined the report of the director of elementary education, while later dated 7 November 2025. There was a report submitted, detailed report submitted by the director of elementary education officer with regard to the points which was asked for by the company. Now we're going to see page 118, 119. That's just reading the relevant questions. Serial number B menu. As per the findings of the state level committee for considering the permission, recognition, upgradation, concurrence of educational institution held on 2005, minimum enrollment in one class should be 30, and if there are more than 55 enrollment in the particular class of the school, may open a new section with prior approval of the DE after fulfillment of necessary condition. In the instant case, the class-wise enrollment furnished by the BO Agumni for the year 1996 and 2008. Although these are the enrollment conditions. So the school was not eligible for opening a new section and also appointment of additional teacher even at the time of appointment of the petitioner during 1996. Also, the enrollment of the school did not permit to provincialize the additional teacher during 2008. Further, no record of prior approval of DE for appointment of the petitioner is found in the record. The appointment of the petitioner by the managing committee does not commensurate with the enrollment of the students in the school at the time of provincialization. Also, the appointment of the petitioner was not done following the existing rules. Hence, the appointment cannot be considered for benefit of interest of the students instead of benefit of the petitioner only. So, based on this, the decision at base 121. The committee has thoroughly examined the report of the DESR, and it is observed that although the petitioner is found to have been regularly continuous services in the school for 2 years immediately preceding the taking over of the school by the government, given the fact that the school was provincialized in 2008. However, the appointment of the petitioner by the managing committee does not commensurate with the enrollment of the students in the school at the time of provincialization. The petitioner was appointed as an additional teacher, and she was not promoted to the post of assistant teacher. Considering the low enrollment in the school at that time, no additional post was required to be created. Yes. So that the Hyper Committee, after following the office memorandum, in terms of the order of the court, has rejected the case of the petitioner. To justify that there was an enrollment position, there was some attendance register produced by the petitioner.
Lordship. Lordship, before going to the directions, what are the finding? Lordship, kindly see the finding. Before going to the direction has been already seen, Lordship. Kindly see the finding regarding peasant petitioner's status, Lordship. This court has given a categorical finding that she is not an excess teacher, and she's appointment of this peasant petitioner is necessity. So this finding already given by this Honorable High Court under after considering all the aspect, Lordship. Lordship, that finding, Lordship, kindly see page number in my contempt petitions, Lordship. Page number 18. Even Lordship, kindly see the first 17, page number 17, para number 10. Para number 10. The first ground. Lordship, here are court finding regarding the additional teacher. Lordship, here in this para number 10, at the first ground as assigned by this High Court Committee toward rejections of the case of the petitioners for prohibition, her service that he being an additional teacher of the said school was not entitled for having her service prohibited in the fact and circumstances of the present case cannot be sustained. Cannot be sustained. Next, Lordship, next, para number 11. The appointment of the petitioner was so necessitated on account of fact that there was a necessity of a graduate teacher in the schools, and recognizing such necessity, the school managing committee had proceeded to appoint her as a teacher in the said school. The nomenclature as assigned to the petitioner on her such appointment of being an additional teacher is of no consequence in as much as the said designations given by the school managing committee when the said school at its fancier space. Lordship, that is important, Lordship. And Lordship, now Lordship, kindly take next paragraph. The perusals of the material brought on record does not reveal that the appointment of the petitioner in the said school was in excess of the requisite number of the teacher mandate to be appointed in the said school. Lordship, that is important, Lordship. He was not excess teacher, Lordship. Further, it is not in contentions either the High Court Committee and the respondent authority that the petitioners appointed as effected on 4/12/1996 was in excess of the required number of the teacher mandate to be available in the school, said school, Lordship. Lordship, next, Lordship, the petitioner could not have been denoted to be an additional teacher, also on the ground that the authority, while provincialization of service of is serving teachers in the said school, had only sanctions a limited number of the post of teachers for affecting the provincialization. It is to meet such situations that where there are the more number of teachers working in a school than and the number of post or sanctions, and that government had adopted the policy available so and so. So, Lordship, here this finding is clearly mentioned, Lordship. Court has come into finding that the present petitioner is Lordship not excess teachers, and her appointment was necessity. Necessity was there, Lordship. And it also mentions, Lordship, though their designation has been given as a additional teachers, but that is not affected, Lordship. Everything, so that finding has been given. So now, Lordship, they have taken in the stand that, Lordship, that at that time of the appointment of the present petitioners, the student ratio was low. So how much students is required, Lordship? Kindly see this legal provisions. How much they did not say anything. And one more thing, Lordship, while this petition has been disposed, then, Lordship, one report has been submitted. In this report, Lordship, it is categorically mentions that one science post was there. So that's why, Lordship, one post was there. That's why this honorable court came into finding that there is no present petitioner was not excess teachers. So now, Lordship, this High Court Committee saying that who was Lordship in report is showing that science teacher, he was appointed in my place, Lordship, my place. So that's why they are saying now they are saying, Lordship, there is no post. So that Lordship, my submission is very clear, Lordship. Lordship, that at confusion created by the department who was working as a science teacher, he was appointed in my post. So that's why, Lordship. And one more thing, Lordship, this finding, when this court has given finding, his present petitioner is not excess teachers. Against that, Lordship, no appeal has been filed. No appeal has been filed, and that is accepted. So even if now they are taking the stand that the student ratio was low, so that means, Lordship, the present petitioner is excess teachers. So while they can, Lordship, while categorically finding is there, this High Court has given finding. Can on this basis of finding, can the respondent overlook, or can they oversight this finding while they are when they are not challenge this order, Lordship? And Lordship,
Yes, Mr. Kosik, it appears that the decision of the High Power Committee is not in accordance with the observation and the direction issued by this court. You see, you see the direction.
The direction is to the hyper committee is to strictly consider the case of the petitioner in terms of 13(1)(20).
No, if this court has categorically observed that the petitioner is not an excess teacher
No, my
or
lord,
additional teacher,
but
from where do you got the authority to again decide the matter that she is excess teacher?
no, it is not decided.
Are
whether
you
that she
are
is
not you sitting in appeal?
No, it is,
Hmm?
the hyper committee has in the decision, my lord,
Hmm.
has additionally said that even at the time of the provincialization, because of the enrollment, there was no requirement for an additional teacher. However, my lord, the report of the director of elementary education, my lord, in terms of the office memorandum which was directed for consideration, my lord,
Hmm.
that office memorandum clearly says, my lord, the report clearly says, even in 1996, my lord,
Hmm.
because the office memorandum, my lord, the direction was to strictly consider the office memorandum, the conditions laid down in the office memorandum.
Hmm.
So in my respectful submission, my lord,
You see, it
what
appears
he's
that
trying- what my friend is trying to say, my lord, he is trying to get an adjudication in a contempt proceeding. My lord.
no. Your order is not appears to be in consonance with the direction issued by this court.
My lord, in my respectful submission, my lord, there is a direction of this honorable court, my lord. There is no willful.
Then
change of
if it is your stand, then we will drop contempt proceeding.
my affidavit is there.
Pardon?
I have specifically stated, my lord,
Maybe,
that
maybe,
the-
maybe. We'll drop contempt proceeding.
And my lord, the verification, the justification of
No.
the petitioner based on the enrollment.
You say, you have been given the last chance to examine the matter again. Otherwise, we'll go for contempt proceeding. We'll resume at 2 o'clock. In the meantime, you go through the order, direction issued by this court, and order passed by the authorities.
Bringing on record the attendance rate, the
Mm.
attendance,
Mm.
and therefore it was verified. If your lordship takes note of that additional affidavit, then my lord, I would like to file my reply to this additional affidavit. If your lordship doesn't take note of that additional affidavit, it's not a problem. Because additional affidavit he has brought on record, the attendance register, my lord. And my lord, in the verification, there is a very serious thing, my lord, found that there is a fabrication of documents. So perhaps, my lord, that would also be important.
Lordship, here in my case, Lordship, just I would like to draw before this honorable court that whatever enrollment is saying, my department, that is not correct. So now they are saying that the Lordship, one register book is not telling, and other is already there. And here it is saying that the admission register book is not there. Admission register book, but student enrollment book is there. So in one book, one sections is not telling, just one. If consider one is not telling, then also lordship students ratio is so high. So my submission is that lordship.
That is accepted that one is not telling, it's a serious thing.
No, lordship. But for sake of argument, I am.
It's a fraud committed on the court.
No.
The documents which is fabricated has been
Lordship, this documents is not in my custody. Lordship, it is kindly peruse one thing, Lordship. Whatever documents I have submitted is not my custody. This documents is custodians of the headmaster, and he has supplied these documents, Lordship. Xerox copies. There, Lordship, this register book is telling. Just there is two register book. One is admission register book, and second is student attendance register book. They're saying, Lordship, the admission register book is not telling. But Lordship, the student ratio attendance book that is telling. So my submission is that Lordship, if in this case Lordship, the clear finding is there. Finding is that the present petitioner is not ex-teachers. And Lordship, why this court came into finding? Lordship, there is a Lordship, one report is there in original writ petitions, Lordship, that there is a teacher's pattern that has been given. After observing all things, Lordship, then Lordship, this court came into finding. So now, Lordship, in this Lordship hyper committee's report, they are taking the different stand. Lordship, their teacher's patterns, so now it's showing this different. Earlier is saying different, now is saying different. So my submission is very limited, Lordship. Now they are taking the stand, just number of the students is low. But how much required, they did not saying, Lordship. But law is very much clear. Though earlier occasions, Lordship, I have brought in this notice before this honorable court. This in 1977 rule, it very much clear how much students is required. Here is mentions, Lordship, only 90 students is required, and one exception is there. Government has a liberty, or government has a power to relax this student number as per their discretion. So here in my case, Lordship, the school was provincialized. All the teaching and non-teaching staff has been service has been provincialized, regularized, except me. Now they are saying the student ratio is low. If student ratio is low, so why other teachers becomes regularized? Then same principle ought to have applied in the other post, Lordship. So my submission is that, Lordship, so when paragraph number 11 and 12 is came into finding that he is not an ex-teacher.
When did you file additional affidavit?
Lordship. Lordship, I have filed 2 additional affidavit, Lordship. The first, Lordship, I am just mentioned and brought into notice before this honorable court, Lordship. Just first, I have filed an additional affidavit regarding, Lordship, that whatever they taken a stand, that already earlier occasion set aside. So ultimately, on basis my additional affidavit, they have withdrawn their rejection order during the pendency of this contempt petitions, Lordship. And now, Lordship, subsequently, they have taken this separate and new stand. Against the new stand, they in new stand, they taken the number of students ratio is low. So that's why, Lordship, I have submitted as the student attendance books, Lordship. Lordship, that is started page 123 additional. And in my additional affidavit, Lordship, it is I have taken the 2 stand, Lordship, pursuant to their I am showing before this honorable court their stand. What is it is prima facie illegal. I have taken in my additional affidavit there are 2 grounds. Mainly, I am taking. I am noticing before this honorable court that one, they're saying that a science research is still vacant, science post. But Lordship, someone is working. He was appointed as a science teacher, but his regularization was done as a assistant teacher. That is my post. Against at Lordship, they did not saying nothing. And Lordship, I have submitted one more thing, Lordship. In the year 2003, there is an inquiry has been carried, Lordship. Inquiry board has been created by this director, and by this inquiry committee, it is reflected that a section was there, number of the student was there. On that inquiry committee, I have annexed, Lordship. That inquiry report has.
Where is that report?
Lordship, in this original writ petitions, Lordship. That is in my original writ petitions.
Where is that order?
Lordship, that page 23, Lordship.
Yes.
Lordship. This is inquiry committee report, Lordship. At that time, Lordship, some dispute was arose. So that's why, Lordship, department has been constituted an inquiry committee. And that inquiry committee has been submitted a report. In this report, Lordship, it is reflected that present petitioner's name and Lordship, that it page 32. Lordship, kindly see the page 32, Lordship. Page 31, the inquiry committee, first page, Lordship, it is the original copy, Lordship, and 23 is the type copy, Lordship. Page 31, that is the starting page, Lordship. 31.
Yes.
Lordship. Here, Lordship, it is mentions the chairman, Lordship, he is the BEO, Glogans. And next, Lordship, he is two members. They are also BO, Lordship. One is Gauripur, one is Agomani, Lordship. So that Lordship, kindly see the next page, Lordship. Next page, 32. Lordship, here is mentions, Lordship, first line, Lordship, it is the teacher's pattern, Lordship. Here is my name is mentions, serial number 7. And serial number 4, Lordship, kindly see, Abdur Rafiq, science teacher, Lordship. Lordship, designation here is mentions, designation science teachers. And my name is Lordship Maloti Vepari 7. And now, Lordship, kindly come into below, Lordship. Below, it mentions, Lordship. On the day of the visiting of this school, enrollment of this Lordship. There here mentions, Lordship, 5A. Total number 31. On the date appears 24. 5B. Lordship, that's in that year, Lordship, in the year 2003, the total number is more than, Lordship, more than, that is total number of students 120, Lordship. In the year 2003, this report is reveals, Lordship. And Lordship, now here it is mentions, Lordship, Abdur Rafiq as a science teacher. And now, Lordship, one report has been submitted by the in my read petitions, Lordship, that their teacher patterns was there. In that report, Lordship, department has categorically mentions that Abdur Rafiq as a science teacher. So now, Lordship, now presently, Lordship, they are showing Abdur Rafiq as an assistant teachers. And science teachers post is still vacant. So that science teachers, Lordship, there is my post. So on that contest, Lordship, everything after going through all the record and on the basis of their report, Lordship, this honorable court came into finding that present petitioner is not access teachers. And pursuant to that notifications, Lordship, whatever notification, Lordship, it's notification deals, Lordship, student ratio, Lordship. What is their stat? Lordship, in this case, Lordship, court firstly, Lordship, court is came into finding that he is not a access teachers. But subsequently, they have taken the same reasons, Lordship. They are now saying that there is access teachers. While, Lordship, student ratio is low, that means I am an access teachers. But court has already came into finding I am not an access teachers. Against that, he is not, department has not challenged. And in my affidavit, Lordship, I have also taken that stand. That, Lordship, is in my
Mr. Kosei, you see, at the time of disposal of this writ petition, this was the figure that was taken into account by this court. Now subsequently, you cannot take a different
No,
distance.
my lord, the declaration 4689.
Yes,
My lord, the
you see
declaration-
this
the
enquiry
declaration-
report,
my lord,
enquiry report.
No, my lord, the enquiry report was in respect of a dispute regarding between these few teachers, my lord, based on which, my lord, there was the provincialization order was kept in abeyance, my lord. And therefore this inquiry was conducted, and after the inquiry
No,
report.
maybe, you see the number of the students.
Page 23 is the inquiry report, my lord will find in the definition.
31, original report.
এটা টাইপ কপি সো এখানে আছে
Yes, page 31. Now my lord will kindly come to. Come to the speaking order. Pursuant to this inquiry report, page 36.
37
Page 37, my lord finds. It appears from the report that the petitioner school so and so.
His number?
Page 37, page 36.
37 of the
Yes.
Findings of it. It appears from the report that the petitioner schools, namely primary ME Madrasa, headed by Ramzan Ali Mondol, was established on 5/2/1971, and the school was recognized on 1/4/1975. School was provincialized on 23/2/1980, but the benefit of provincialization of the school was kept in abeyance due to some dispute among the members of the staff and the public and the members of the managing committee of the school. In the meantime, the self-styled madrasa was started by some same name, misleading local person in 1993, headed by Saiful Islam. In pursuance of the order dated 2000, passed by the Honorable High Court, in CR case number so and so find out the original school, a inquiry committee was constituted by the DO, and the inquiry committee finds that Koimere ME Madrasa, headed by Sri Ramzan Ali Mondal, was established earlier than the other ME Madrasa headed by Saiful Islam, and recommended Koimari ME Madrasa, headed by Ramzan Ali Mondal, as the original madrasa. Meanwhile, the petitioner Ramzan Ali Mondal retired from so and so, promoted to the post of senior most assistant teacher, Sri Abu Bakr Siddiqui, as the headmaster of the said school. In view of the facts of the state above, on the basis of the inquiry report submitted by the inquiry committee, the order passed to keep the provincialization of Koimari ME Madrasa, headed by Ramzan Ali Mondal, in abeyance, is hereby vacated. So, my lord, there was a dispute with regard to the existence of.
No, that's all right.
That
But
was the crux of the inquiry.
no, that's all right. Here you see the number of enrollment.
Yes.
Here it is clearly mentioned class 5A, 5B.
Yes.
Enrollment number is also 24 and 21. Then if at the time of disposal of this writ petition, this was the figure, then this subsequent generation of this information and rejection of the claim is not at all acceptable.
Sorry.
This your report is not at all acceptable.
But
The report you have produced here in the last part, it is mentioned that the claim of the petitioner having two sections in class 5, for which the petitioner has claimed that her appointment is valid, is not found to be fact.
Here, my lord,
You see here in the report, you see.
Your lordship will kindly read from fourth paragraph of the report. Third paragraph, sir. Starts with, in those connection, it is stated that additional affidavit of the petitioner has stated that enrollment was 57 in class 5 showing two sections in class 5 A and B during year 1996. That is the claim of the petitioner, that there were two sections. However, during verification of the admission register of class 5 during the year 1996, the names of the students enlisted in attendance register of class 5A during 1996 were not found in the admission register. It is also verified whether any repeater student was in class 5. So the admission register of 1993, 94, 95 were also examined. But the names of the students of class 5A are not found during this period in admission register.
No, if this report speaks that there are two sections.
It is his claim, my lord, in the additional affidavit. That there
No,
are
no,
two
no, no.
sections.
This report is for this report was prepared by three BEEOs.
Inquiry report.
This is an inquiry report. And on inquiry, it was found.
So this inquiry report is not the basis of the order judgment passed by this honorable tribunal.
No, maybe this was part of the record and it was
But
considered.
part of the record in this NIS petition. I don't know whether it was part of the record in the earlier petition or not.
No,
That
this
is-
is
This is a pending petition.
No, no, no.
Which one? No, this was a petition.
The 4960.
No. দুটাতে সেম ডকুমেন্ট
WPC 4960.
4689 2021.
না না এইটো আপোনাক মই ডিসপোজ করব
4689. But this is not the basis of the judgment, my lord, where is the contempt and challenge, my lord? It page 66 is the judgment of that petition, my lord, kindly see.
No.
Based on the finding, my lord, lordship is kindly appreciate, my lord. Based on the findings of 10 and 11, my lord, at paragraph 10 and 11, this honorable court has taken a decision at paragraph 19, setting aside the decision of the High Court Committee, which was a subject matter of challenge in that petition. The consequence of that finding is the order at paragraph 19, setting aside of the interference with the earlier High Court Committee report, wherein his case was rejected.
No. We are concerned with the number of sections that have been found by the inquiry committee and the number of enrollment.
Hello.
See,
No, that I have got it, my lord. But this is
See.
this instruction is in respect of the contempt, my lord. In the repetition, I have not-
maybe
in not my affidavit.
contempt case arose out of the writ petition. Non-compliance of the order passed in the writ petition.
My lord, in my respectful submission, my lord, the finding which my learned friend is stressing upon, my lord, that finding, the consequence of that finding is the order of the court is at paragraph 19. Based on that finding, already this honorable court has interfered with the earlier order of the High Court Committee. There were further directions.
No, that's all right. You have mentioned the figure here that there is no two section in class 5.
Yes.
But this report shows that there are two sections,
The
5A and 5B.
I'll have to take clarification about this, my lord. Because this verification was done based on the record that is available in the additional affidavit.
Maybe you say this finding you have arrived at
Based on the documents placed before the court by way of an additional affidavit.
No.
Yes, my lord. Your lordship will kindly see, my lord, the second paragraph.
No, you see, this observation made in this last paragraph is palpably wrong in view of this inquiry report. Okay. We drop contempt proceeding. Let notice go.
Yes, your lordship is taking note of this report at the additional affidavit.
Okay.
Then my lord will give me, or your lordship will record that my lord I produced.
Which one?
This report.
Yes.
If your lordship is taking note of that additional affidavit,
We are taking note of everything
then my
that
lord
have
will-
been placed before us.
yes, my lord will then record by submission my lord, that I have placed this. My lord.
Which one?
The instruction which I placed.
Okay.
Okay. And my lord will also record my submission that the direction of this honorable court has paid. Paragraph 20, 21 and 22.
Okay. We'll pass the order.
My lord. I am representing this for number 1. And my I have filed my affidavit.
And who is for respondent number 2 then?
My lord, Director, the two in respect of 2, my lord, I can appear, my lord, but respond number 2 or direction was only to place it before the high power committee, and it was placed. So in the direction in respect of 2 was only limited to placing it before the high power committee. And apparently, my lord, it was placed.
And lordship, I think 3, 1 and 3, the same lordship. I think my learned friend will be appear.
1 and?
1 and 3, respondent number 1 and 3 lordship. So let us say with this. Diana and appear. And the Lordship, in the last occasions, lordship, the ANZAC attorney also already informed lordship he is API, lordship. In respect to contempt number 3.
Basically, 1 and 3 are the same person.
Same person.
3 has been implemented in this capacity now as a member secretary of the high power committee. Lordship will also want one submission. Lordship will kindly record that. The direction, the second direction at paragraph 20 was to the high power committee. And the members of the high power committee are not the party. It is only the member secretary who is the party.
Okay.
Coming item
Highly
28.
appreciated.
In the repetition, my lord, I will file my affidavit. 3 weeks time.
May I please, lordship? My lord, in this petition, the petitioner challenges an order, my lord, by which, my lord, the land grabbing proceeding has been dismissed, my lord. The impugn order, your lordship will find at page 60, my lord, annexure 10.
Page number?
Page number 60, annexure 10. The petitioner filed an petition under section 8(3) of the Land Grabbing Act that has been dismissed, my lord. On a very silly issue, my lord. Annexure 10, my lord. 10. So the impugn order says, my lord, all 5 petitioners are present with their learned counsel. Learned counsel for the petitioner as well as respondent number 1 and 2 are also present. Heard them as well as parties. We have already specified in order dated 24/9/2025 that report from the circle officer was called on 30/8/2024 before taking cognizance. The report was submitted. Thereafter, another report was called from OC of Murachar PS by order dated 28/10/2024. Thereafter, the case was posted for hearing on so-and-so. But ultimately, someone was sent on 18/1/2025 without any order on cognizance. Thereafter, respondent number 1 and 2 have appeared and submitted WS. It is clear that there were some irregularities in the matter of taking cognizance, which can be rectified streamlined now after hearing the learned advocate of both the sides. Cognizance is an important matter and section 8(3) proviso of the Assam Land Grabbing Act specifically says that special tribunal shall not take cognizance of any such case without hearing the petitioner or the aggrieved person as the case may be. Honorable Gauhati High Court in so-and-so case stated that all the section 8(3) of the Act 2010 is that for the purpose of taking cognizance, the special tribunal may consider the location of the land alleged to have been grabbed or the estimated value of the land or the nature of the land grabbing or such other relevant matter. In view of the above laws, this court is inclined to hear the learned advocates of both the parties on the next date. This court shall also hear the petitioner aggrieved person on the next date personally. After personal hearing of the petitioner as well as the learned advocate for the petitioner, we find that this petition has been filed only for 4 katha and 10 lesa land in Kopahbari Moja, which is a village land. The quantum of land is also very less. This is relevant, my lord. The quantum of land is also very less. Therefore, it appears that this dispute is not connected to organized attempts of land grabbing, which is dealt by Assam Land Grabbing Act 2010. Because the land is very less, my lord. The preamble of the Act of 2010 makes it clear that this act is applicable only for organized attempt on the part of lawlessness person in order to grab land. Honorable Gauhati High Court in the case of so-and-so has specifically laid down law that the value of the land as well as the location of the land is also significant. Such being the position of law and fact, we are of the opinion that this is not a fit case to take cognizance under Land Grabbing Act. The petitioners are so-and-so. So, my lord, the issue, the main reason is that the value of the land is very less, my lord. 4 kotha 10 less are less. And the learned court below has referred to the judgment that, my lord, this is the judgment your lordship may peruse, my lord, which says, my lord, the procedure to be followed. Para 21 is the
What is the requirement?
requirement is, my lord, before taking cognizance, the preliminary hearing has to be there. So prima facie satisfaction has to be there. In this case, my lord, apparently, initially, the notice was issued before.
No. Here the trial court has observed.
Yes.
Not trial court, it is a tribunal.
Tribunal, special tribunal.
Tribunal has observed that the quantum of land is very less.
There is no any such requirement in the Act, my lord. Your lordship may peruse the Acts as well as the para 21 of this judgment, my lord. Value of the land or quantum of land, it may be 1 katha, 2 katha, but location or that has to be considered. But because it is less, my lord, that cannot be under the previous bit of this act. That is not there. Para 21 of the judgment, my lord, your lordship may peruse. Insofar as the question number 2 is concerned, all that section 8(3) of the 2010 Act says is that for the purpose of taking cognizance, the special tribunal may consider the location of the land alleged to have been grabbed or the estimated value of the land or the nature of land grabbing or such other relevant matter. This is very much in order that there is nothing unusual about it. So it has to be considered for this purpose, that this is very much in order and there is nothing unusual about it. Regarding the proviso, it says that the special tribunal shall not take cognizance of a complaint without hearing the petitioner or the aggrieved person. So in this case, initially there was a mistake, my lord, that has been rectified because, my lord, without hearing the petitioner, the notice was issued. But subsequently, there were reports of the concerned circle officer and OC that has been called for. I have annexed here also. So from their prima facie, there is a prima facie. It is seen from the reports that, my lord, the material ingredient of land grabbing is there, my lord. So on the basis of those 2 reports also, my lord, the cognizance can be taken, my lord. That 2 reports also I have annexed, my lord. Your lordship may peruse later. So these
the tribunal has not dismissed your case considering those reports.
Yes.
So
it has dismissed.
Tribunal has dismissed your case only on the ground that
Land is
the
very less.
quantum of land is very less.
Yes, my lord.
But there is no such statutory requirement.
No such statutory requirement, and the judgment of this honorable court.
No, whether it is provided in the rule.
No, my lord, it is not, nowhere it is there.
Nowhere.
Nowhere in the act or rules, my lord, not even in the judgment, my lord, the judgment.
Then
that has been-
okay, we set aside this order. We
Yes, my
remand the
lord.
matter to the trial
Yes,
court.
my lord, that is my limited prayer.
Approximately, say the provision of the land grabbing act.
Yes,
Relevant provision.
yes.
Uh,
Which is the relevant provision?
Yes, section 8, subsection 3.
Mm. Yes.
Subsection 3. The special tribunal, for the purpose of taking cognizance of the case, consider the location or extent or value of the land alleged to have been grabbed or of the substantial nature of the evil involved in the interest of justice required, and any other relevant matter involved in the case. This is their lordship. As per this provision, the learned tribunal has decided, lordship. Lordship can see the observation made by the learned tribunal.
No. You say, here the primary consideration of the tribunal was that quantum of land is very less.
That is here in the
For kotha 10 lasa. But it has not been provided in the act.
Yes, value of the land is there, location
Value.
is there, everything is there.
No, whether this value is quantified here.
No.
Lordship, kindly see the order passed by the learned tribunal.
Yes.
Apart from the quantum of land,
Mm. Mm.
there is another objection. Therefore, it appears that this dispute is not connected to organized attempts of grabbing, which is built by Assam Land Grabbing Act.
Mm.
These are the conditions required.
Mm.
There has to be attempt, organized attempt to
Mm.
grab the land. That is not there.
Where it is provided in the act.
Lordship,
Definition is section 5.
Section 8 itself, Lordship.
Pardon?
Section 8 itself, Lordship.
No. Section 8 is not a. That is regarding power and function. What is the offense? Offense is penalty is provided in section 5.
Penalty, Lordship.
Mm.
Section 5 is relating to.
That portion your lordship will find it preamble, my lord. Preamble of the act, my lord.
No, it should be in the act itself. No?
Yes, my lord, it is not there, my lord. And otherwise, my lord, whether attempt is there or not, how it can determine before.
Mr. Bora, you say, what is the ingredient of the offense?
Yes.
To see the ingredient of the offense, we have to go to the definition of the offense.
Yes, my lord.
Offense is defined in section 5.
Yes, my lord.
Land grabbing, section E, Lordship, 2E. Section 2E is land grabbing.
Hmm. That is the definition of land grabbing.
Yes, Lordship. Definition of
Offense is 5, section 5.
Right.
Five A, my lord.
Mm.
Or has in his possession for the purpose of sale or allotment any land grab.
Mm.
So your lordship may now peruse the report of the circle officer and concerned officer in charge, my lord. That is, my lord, concerned circle officer report at page 40, my lord. Page 40, my lord. In citing the reference. above,
42 is the vernacular.
Yes, my lord. Vernacular is in the page 42, my lord. Abdul Wahid is the father of the petitioner, my lord. Then, my lord, page 43, my lord. And vernacular is page 44, my lord.
Initially, lordship, the land was.
As per page 43, also relevant, my lord. At present, some other patladars have been possessing the land by fencing the said land.
Initially, the land.
And my lord, then my lord, the report of the concerned OC, my lord, that was also called for Annexer 7, page 47. The lord signature, page 47, my lord. First party is the petitioner herein, my lord.
Second party is the accused person.
Yes, my lord. Respondent. Petitioner is the first party. So apparently, my lord, materials are there, my lord. Initially, my lord, the report from the circle officer and OC was called for. But subsequently on this ground, my lord.
Report was called for by the tribunal.
Yes, my lord, that.
Annexer 7.
Yes, my lord. Report call for order, your lordship will find at page 38, Annexer 4, my lord. The tribunal, order passed by the tribunal, page 38, my lord. By the order at page 38, the report from the circle officer was called for, my lord. Subsequently, my lord, by the order.
Mr. Bora, you say the tribunal has only considered the quantum of the land.
Yes, my lord. Only
and
on
value, and though this court in the division bench of this court observed that the value of the land
yes,
as well as location has also to be taken into account.
Yes, my lord.
But nowhere it has been taken into account. What is the value of the land?
Yes, my lord. Nothing has
That
been
was
taken.
not before the tribunal.
Yes, my lord. Nothing, my lord. Only because it is saying that the quantum of land is very less, my lord.
While the Act does not provide any such criteria,
Doesn't provide.
then from where the tribunal got it?
And what will be the less amount or a
Yes.
that cannot be determined, my lord. And otherwise also from our common knowledge, my lord, 4 kotha 10 lesa, almost 1 bigha land.
1 mega land, yes.
That is not a small plot of land, my lord.
That depends on the area of land. That depends.
Maybe.
Lordship,
The value is not specified.
Yes.
That in the act.
May I make my submission, Lordship?
So in my humble submission, my lord, your lordship may remand back the matter for the adjudication, my lord, by the tribunal, my lord.
Lordship, kindly come to the definition part, Lordship. Section E, land grabbing. Land grabbing means every activity of land grabber to occupy or attempting to occupy with or without the use of force, threat, intimidation, and deceit, and any land, whether belonging to the government, undertaking a local authority or religious or charitable institution or endowment, including a work or any other private person, over which he or they have no ownership, title, or physical possession, without any lawful entitlement. And
No,
with-
now you come to Annexure 7, the report of the officer in charge.
Lordship.
On 10, a middle part. On 10/10/2024, a temporary Katsa house was constructed by the second party.
This is what we have
On
applied.
11/10/2024, one shop installed in the disputed land. Is it not land grabbing?
No, Lordship, I have stated in my objection, Lordship, that this part of land belonging to the forefather of the petitioner, Lordship, of the respondents. This land was.
No, that has to be determined. That has
Yes,
to
my
be
lord. That
determined
has to
only
be
during trial.
adjudicated by the tribunal, my lord.
No, Lordship, for a moment. The forefather's
No,
land
no,
was
you see.
exceptional land.
No, Mr. Islam, you see.
Okay.
Here we are not on the merit of the
Yes,
case. We are testing the order of the tribunal. Then it appears that this finding is perverse. Because the act does not provide for that for less quantum of land cognizance cannot be taken.
The document on the strength of which my language is claiming that the portion of land is belonging to them. We have filed a civil suit, Lordship, in the court of learned.
That's all right. That will be considered in
Yes,
due
ma'am.
course.
Learned civil judge Hudai, Lordship, for some of the.
Maybe.
My learned humble submission is that as the right title and interest is involved of both the parties, their revenue records are corrected in the name of both the parties, Lordship. So, Lordship, my humble submission is that we have filed civil suit and my learned trained may.
No, there is no bar.
Participate in.
There is no bar in prosecuting this case before that special tribunal.
So this may be closed, Lordship.
Is there any bar?
No.
No, there is also no bar, Lordship.
Then
The provision.
Then under what provision I will exercise that power?
Otherwise, a parallel proceeding would go, Lordship.
No, my question is whether such a proceeding is barred by law or the rules.
But
Then
parallel proceeding also not.
heard Mr. D.P. Bora, learned counsel for the petitioner, and Mr. Islam, learned counsel. No, Mr. Am I Hussain, learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 30/10/2025, passed by the learned additional district and sessions judge FTC Huzai in special land grabbing case number 05/H of 2024. It is to be noted here that by the impugned order dated so and so, the learned tribunal has dismiss the case of the petitioners. Mr. Bora, learned counsel for the petitioner, submits that the petitioners have instituted. Where is that complaint lodged before the tribunal?
My lord, complaint is annexure 3, page 31.
Lodged the complaint under section 8 of the Land Grabbing Prohibition Act 2010 before the Court of Learned Additional Session Judge, District and Session Judge FTC Hosai, and upon the said application, the learned court below has issued notice to the parties. Where is that order? Issuance of notice?
My lord, that order is 38, my lord.
Page number 38.
Page 38. 38, 2024. The report from the circle officer was called for, my lord.
On receipt of the complaint, no, on receipt of the application under section 8, the learned tribunal has called for a report from the circle officer Doboka. With a reference to the revenue record and facts on the following grounds. Number 1, correctness of statement made in the application. Number 2, the fact relating to the ownership, actual possession, and use of land concerned. Number 3, such are the other particulars and information as may be useful for the tribunal to arrive at the correct decision. And thereafter lists the matter on 22nd of October 2024. Accordingly, the circle officer Doboka, Revenue Circle, submitted his report on 21/10/2024.
Then, my lord, page 45, next order, my lord. The report from the concerned OC was called for, my lord.
Thereafter, the learned tribunal by order dated 28/10/2024 has called for a report from the officer in charge, Morazar Police Station, and fixed the matter on 25/11/2024. And accordingly, the report has been received from the circle officer, from the officer in charge, Morazar PS Hosai, on 28/11/2024, and thereafter fixed the case on 6/12/2024 for hearing. Thereafter, what happened?
My lord, in the meantime, they also filed WS, my lord, and thereafter the order at page 57, 24/9/2025.
Thereafter, the respondent hearing entered appearance and filed a written statement. Now, whether notice was issued to them?
My lord, specifically, there is no order issuing notice, my lord.
But they have appeared.
Yes, my lord.
Entered appearance and filed a written statement on when it was filed.
My lord, it was filed on
Notice.
Notice.
When it was issued.
Okay.
Mhm.
And orders did not.
No, when you have filed the WS,
WSP did file calculated date. WS is at page 48, my lord.
5/4/25.
5/4/2025. 2025. Thereafter, the learned tribunal has fixed the matter on 24/9/2025. And again, lays the matter on 30th/10/2025. And on that day, after hearing both the parties, the learned tribunal has dismissed the case of the petitioners only on the ground that the petition has been filed only for 4 katha and 10 lesa land in Kopabari Moja, which is a village land, and the quantum of land is also very less, and therefore it appears that and thereafter the learned tribunal has observed that this dispute is not connected to organized attempt of land grabbing, which is dealt by Assam Land Grabbing Act 2010. And thereafter, discussing the preamble of the act and also considering the observation made by a division bench of this court in High Court, in reference State of Assam, reported in 2018 to GLR 313, where it has been specifically laid down that the value of the land as well as the location of the land is also significant, and thereafter, considering the position of the land and facts, the learned tribunal held that this is not a fit case to take cognizance under the Land Grabbing Act, and thereafter dismissed the same. Mr. Bora further submits that nowhere in the Act or the rules it is provided regarding the minimum quantum of land for which the cognizance of the offense can be taken, and the value of the land and the location has also not been specified in the Act. And in that view of the matter, the impugned order suffers from material irregularity, and under such circumstances, he has contended to allow this petition by setting aside the impugned order and to remand the matter to the learned tribunal for consideration afresh. On the other hand, Mr. Hussain, learned counsel for the respondent, has supported the impugned order dated 30th/10/2025. He submits that the land was in possession of the respondent, and he inherited the same from his forefather, and his name is also their name is names are also mutated in the revenue record. Revenue records. And further, Mr. Hussain submits that in respect of the said land, the respondent herein have already instituted one title suit, being title suit number
2026.
10 of 2026, and which is pending for adjudication before the Court of
Civil Judge Junior Division.
Civil Judge Junior Division, Huzai, Sankotem Nagar. And as such, two parallel proceedings cannot be allowed to be run, and in that view of the matter, the impugned order suffers from no infirmity requiring any interference of this court, and therefore Mr. Hussain contented to dismiss the petition. But having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 30th/10/2025. And it appears that the learned tribunal has dismissed the suit of the petitioner only on the ground that the quantum of land is very less. And as such, this is not a dispute connected to organized attempt of land grabbing, which is dealt with by the Assam Land Grabbing Act. And further, it appears that the learned tribunal has also taken note of the observation made by this court in reference case number State of Assam reported in 2018 to GLR 313 in respect of the value of the land and the location of the land. But indisputably, nowhere in the act or in the rules framed thereunder the quantum of the land has been mentioned. And further, the value and location has also not been mentioned in the act and rules, though the same has been observed in the decision of reference State of Assam 2018 to GLR 313. Since the act and the rules are silent regarding the minimum quantum of land for which cognizance can be taken, this court is of the view that the finding, the reason assigned by the learned tribunal for dismissing the petition filed by the petitioners under Section 8 of the Assam Land Grabbing Act is illegal and arbitrary, and in that view of the matter, the same warrant interference of this court. Accordingly, the impugned order dated so and so stands set aside and cause. The matter stands remanded to the learned tribunal to afford an opportunity of being heard to both the parties and thereafter to decide the matter at rest.
May I pray for one observation in my submission regarding section 8.3.
8.3.
No. Regarding section.
Okay. 8.3.
Your lordship may direct the parties to appear within a certain period.
Both the parties are directed to appear before the learned tribunal on or before
2 weeks.
I have a permission of 3 weeks.
2 weeks. Registrar shall return the record of the learned trial court forthwith.
2020.
Deeply obliged.
For hearing on order 41. Item number 8 and 9.
May I please, your lordship. Lordship, conducting counsel Mr. D.K. Das is currently out of station due to his some medical issues. So lordship, kindly matter will be adjourned for today and fix it for 5th of March. Lordship.
5th of March.
Yes.
Mm.
On perusal of the record, your lordship will find that this matter is pending since long. And the lordship has already been heard on the point of substantial question of law. Thereafter, the matter has been sent for the mediation. They have taken twice as time for mediation. They have also sat together, but later on they retracted. Again, matter has come before this honorable court. On the last occasion, it is fixed on some other court. Thereby, the order is there. They have to produce the authority under section 55. That is during the vacancy of the any judicial member, whether the order passed sustainable or not, whether it will invalidate. To that effect, they are asked to produce the authority. Hearing is already over. And in this fashion, they are taking time from last 1 year. So now it is up to the lordship how to dispose of this matter. There is a concurrent finding in this. It is not yet admitted.
No, if the conducting counsel is absent, how can we hear the matter
But
today?
this practice is going from last a number of occasions. It's not a single instances. Otherwise, I would have been the last person to say object anything. So since it is an appeal, it can be decided on merit if they are not in a position
no.
to argue the matter on merit.
The appeal is yet to be admitted. No stay
Yes,
order
yes,
is granted.
But they are, yes, yet to be appealed. They are not in a position to clarify the substantial question of law.
No, that's all right. That is their failure. If they fail to suggest substantial question of law, definitely we will not admit this appeal.
Yes, you are not saying. So.
So, but today the conducting counsel is absent.
This is the position wise what I have applied before your lordship.
Heard,
Because-
Mr.
SK Lahon on behalf of
SK
Mr.
Lahon,
But let
learned
it be
counsel,
fixed on day after tomorrow, your lordship.
Mr. D.K. Das, learned counsel for the learned counsel for the appellant and Miss. Your name, please. Your name, please.
M. Kumari.
M. Kumari, learned counsel for the respondent. Mr. Lahon submits that conducting counsel, Mr. D.K. Das, is out of station.
Yes, Lordship.
But today morning I have seen him here in the
No,
court.
no, Lordship, he is in Nagaon due to his health.
Today or yesterday, we have seen him.
Yesterday, maybe he was there. But today he went to Nagaon, Lordship.
And thanks for listing the matter on some other day. They are allowed recessal list the matter on Monday.
Look,
as first item.
No, Lordship, fix it for 5th March.
5th March.
5th March, sir. Okay.
Okay. 5th of March. As first item.
March supplies.
You see, if on that day the council is found to be absent, then we will take a stern action. We may dismiss the appeal also.
Mr. Roshi. My lord, is a concurrent findings. The present, my lord, appellants were the defendants. And the respondents plaintiffs file a suit for declaration of right title interest and recovery of possession. Their suit was allowed and in appeal it was affirmed. Then my lord, the second appeal. Now, what is the plaintiff's suit, my lord? Plaintiffs filed suit while for declaration on the basis of a sale deed. They purchases land, plot of land, that is, my lord, 1 bighah of land by registered sale deed in the year 1983. And that was exhibit 3 and 4. And defendant's case is that, my lord, they purchased a plot of land, 2 bighah, 3.5 lesa, from the same dag by registered sale deed. And they are possessing their land. Now, question is that, my lord, whether the plaintiffs could prove that he has purchased this suit land by that registered sale deed, that is exhibit 3 and 4. Because that exhibit 3, it is admitted that was a dilapidated condition, so certified copy was, my lord, produced, exhibit 4. Case 3, substantive question of law.
Sir Hawk, sitting in second appeal,
Mine.
this court cannot decide whether there is cause of action or not.
No, no, my lord.
That
is-
cannot be a
it are-
substantial
There
question of
cannot
law.
be, but page 3, my lord, it can be seen. Page 3, 1 and 2. Subsequently, this is incorporated and I have taken permission from your lordship also. Page 3, 1 and 2. The certified copy, whether presumption can be drawn from the certified copy of the sale deed.
Whether the trial court and the first appellate court has a drawn presumption
Yes, yes, that is the
in respect of a
yes,
sale deed.
that exhibit 3 and 4. Exhibit 3 is a dilapidated consistency admitted. Exhibit 4 is the certified copy of a sale deed. Their sale deed 1 bigha. We purchased 2
No,
bigha.
that sale deed is of which year?
1983.
80.
30 years completed. It is
Yes.
correct.
Then
But
why
question is that
presumption?
it is
That is statutory presumption.
yes, the certified copy, whether certified copy of the sale deed can presumption can be drawn against that certified
No,
copy
no.
of the sale deed.
The original sale deed is produced. That is in dilapidated condition.
Not
And therefore certified copy is
certified.
produced. Then
then my lord, then
had the original document been not there,
not there.
then
Then
the
certified
position
copy
would have
can be
been different.
No, certified, it is dilapidated condition, it cannot be, may not look into.
No,
is
that's
the-
all right. But original is produced.
Produced, because
Produced.
I'm not denying. The certified copy was produced, now presumption can be drawn on the certified copy. Supreme Court said no, it is a copy.
Since original is produced,
Because in original, from original, we have to presume the signatures, contents and attestation, all these things. If it is not there, because it is dilapidated, that is why the certified copy was produced.
no, that's all right.
Right.
Certified copy is produced from the original one.
Yes, certified copy from the sub-registry.
Yes.
So that can be done or not.
Definitely, definitely, since original is there.
Whether we can say
Is
that.
it your case that certified copy is not made out from the
No, no,
that held
we
it?
cannot. We can say because the authority was not, my was produced before the court. Because any officials from this
No,
registry
no,
office,
what is the requirement of the section? It has to be produced from a lawful custody.
lawful custody, that is for the purpose of original one, not for the certified copy, because it is it will be given by the sub-registry
No,
office.
here original one is produced.
Yes.
But since it is not legible,
Yes.
therefore the certified copy is
Yes,
produced.
now question is that how it will be proved? It must be proved, no. Because suppose it is presumed that it is certified copy, then sub-registrar officer should be called for prove these documents also. That was not done.
Let us see the finding.
Mine. Your lordship, kindly see the appellate courts. Finally, page 27 it starts.
27.
Page appellate courts. Para 20, it starts from para 29, 32 possibly. From 29 it can be. Page 27.
No, is it your case that the certified copy so produced is not the not prepared from the original sale date
original one.
produced?
I'm not saying that, but
Then?
they are to burden is like upon them
Then
to prove that this exhibit
no,
here is.
Mr. Hawk, you see, they have produced the original copy. If
That-
it is dilapidated condition,
My lord, it is not understandable. It is written also. It is not understandable.
then therefore they produce the certified copy.
Suppose, my lord, I have not produced the original one. Certified copy also can be produced. There is no any bar, certified copy of the sale deed can also be produced.
But in
Now-
that case, this presumption will not be available.
Will not be available. That is the question. Now, it can be, presumption can be drawn. Now, question is that here the presumption has been drawn from original one. That is the exhibit
No,
3.
yes, only in respect of the original copy, presumption can be
If
done.
it is not understandable, then how there can presumption
No.
can be drawn?
In that case, if you have a challenge,
No,
the certified copy,
No, certified
then
copy-
then it would have been justified.
one I have taken a ground that certified copy, suppose certified copy was produced. So that is also to be proved by calling the officer from the sub-register. No evidence. Simply it is submitted before the court, this exhibit 3, exhibit 4. And no evidence has been laid before the court to prove these documents. That is my case.
Whether you have cross-examined on the
Yes,
certified copy.
yes. We have cross-examined, but they have not stated so. I have not cross-examined. They have not produced any documents also. Then I did not cross-examine them on this point.
So having not raised the issue before the first appellate court, can you raise the same before the second
It's a
appellate court?
question of law that can be also possible. It's question of law. Well, because even this issue has been decided by the appellate court also, section 90 or 92, whatever. And also in the trial court also. It is not that in second appeal I have raised this question. In trial court also it says that it is dilapidated condition, so certified copy was brought. They have to prove the document. That is my case. At any cost, they have to prove the case because that is their case. The trial court says that no, you have not challenged. I have not challenged. It is correct. But they are to prove their case, that is their exhibit 3 and 4. They have purchased the land, that 1 acre of land by registered selling.
You see, they have produced the original copy. And since it is not legible, they have produced the certificate.
And also certificate
You have
copy.
not
Then
disputed
also-
the same.
Then also, my lord, under section 60 of the evidence across 65, they are to prove by calling the officers from the sub-register. They are to prove. Simply saying that it is a 30 years old documents cannot be, my lord. And no evidence in regard that sale deed. Even the certified copy or original one. Original upwards on, of course, for 30 years, the witnesses may not be there. At least that certified copy to prove that officers from the sub-register is required. That is what second question I have raised.
So practically 1 and 2 are safe.
Why,
Question.
what's say?
So one question can be, one substantial question of law can be
Yes,
formulated on
yes,
this point.
yes.
But before that, we have to ascertain whether by producing the original copy,
My lord.
the plaintiffs are relieved from proving the certified copy. That has to be looked into.
I'm leaving to your lordship, but this is my case only.
No, that's all right. But we have to see before admitting the appeal.
Yes, that is correct.
You see, if there is any authority on this point.
Authority is that the certified copy presumption cannot be, my lord.
No, that is well settled.
Yes,
But
yes.
since original copy has been produced before the court and exhibited.
Then, my lord, another question may come, my lord. Suppose original is given. Suppose certified copy is not there. Original is given. That also he has to prove. Only presumption, only presumption in respect of authenticity of the signature.
Yes.
Contents, my lord, they have to prove the contents of that sale deed also. That is not done.
Not done.
Not done. Some evidence must be there. Authenticity, that is correct. For presumption. Suppose a certified copy, there is no certificate. Original one also, then they have to prove. That is not done. That is my view.
Okay.
Actually, there
We will list the matter on Friday.
This Friday. Monday. Can you do Monday, man?
Monday.
Friday, sir.
Okay, Monday.
Monday.
Heard Mr. Hawk, learned counsel for the appellate. List the matter on Monday for further consideration. You say, Mr. Hawk, if any authorities.
My lord,
available-
I will try to.
On.
Your worship. My lord, this appeal is directed against the impugned judgment of the learned lordship, lower appellate court lordship, by which learned first appellate court lordship remanded the matter to the trial court again lordship, partly allowing the appeal lordship. What was happened lordship? A title suit was filed. We are the defendant in the main title suit lordship, and the respondent
Remanded the matter to the trial court.
trial court lordship, along with and allowing the lordship appellant to make the two parties as a party respondent in the trial court, meaning thereby reopening the suit lordship.
No, if non-joinder of those parties,
Yes, lordship.
the dispute could not be adjudicated, then what wrong with the order?
Because lordship, the materially lordship, the appellate court cannot cure the
Here,
defect.
learned appellate court has not finally adjudicated the matter.
Yes,
It has remanded the matter.
lordship.
Whether second appeal will lie on this point.
Lordship, on that issue, may I pray your lordship, this matter may be fixed after lordship 24th or 25th of March, lordship.
Why?
Because today actually due to fasting lordship, I am feeling
Okay.
thirsty lordship.
Okay.
So on 26th lordship of March.
26.
Yes, lordship.
Okay. Heard, Mr.
NH Borbuya.
N.S. Borbuya, learned counsel for the appellant. Place the matter on 26th of March for further consideration. Okay.
Obliged.